organization has a long-term cooperation. As you know, the Venice Commission was one of the first structures of the Council of Europe that started to actively work with Kazakhstan in the field of constitutional justice, as well as in other issues related to different state institutions. And right now, given all the previous years, we see that more of the divisions of the Council of Europe start cooperating with Kazakhstan, and this is a gradual cooperation, and the range of issues that we discuss is expanding, and it is really great to see that from more general topics and more general meetings, we are moving towards specific actions and specific discussions. And our event that is being held today and tomorrow will help us consider in greater details four very important areas which we will develop under our cooperation with the Supreme Court. And from the agenda, you can actually see that we're going to talk about the adversariality of criminal proceedings with the use of those reforms in the field of administrative justice that are actively being held in Kazakhstan, and we will talk about general issues related to the standards in the field of justice. We will exchange our experience on this topic, and our fourth session is going to be very important, as it will help us define or clarify those areas where we will be able to implement specific training programs for lawyers and legal professionals in Kazakhstan. And I think that the Chief Justice will be able to cover this during his speech, as well as the representatives of the Council of Europe and the European Union, which actively support the work of the Council of Europe in this area. As you know, this event, just like many other events, are being held under the rule of law program in Central Asia, which is not only being financed but actively supported by different stakeholders such as European Union and EU office in Kazakhstan. Unfortunately, the Director General of the Legal Department of the Council of Europe is on a business trip, so he couldn't connect us online today, but it is a great honor for me to pass the floor to Mr. Mikhail Lobov, the head of the Department for Integration of Standards in the field of human rights, justice and legal cooperation of the Council of Europe, who will speak on behalf of our organization. Mikhail, the floor is yours. Thank you very much, Sergei Anatolievich. In order to support the bilingual nature of our event, let me say a couple of words in the English, and then I'll finish in Russian.
So, dear President of the Supreme Court, dear Ambassador, ladies and gentlemen, so it's a great honor, of course, to welcome you on behalf of the Council of Europe, on behalf of the Director General of Human Rights, but also other structures of the Council of Europe here represented. Face-to-face meetings are relatively rare today, and therefore all the more valuable. Of course, it is a great pleasure to see some 30 participants around this table and more who follow us online. I'm extremely grateful to all participants who have managed to come to Kazakhstan today from all over Europe to discuss topical issues of justice reforms in the light of best international practices. I would like at the outset to thank our host, Chief Justice Asanov, and the Supreme Court of the Republic of Kazakhstan for their readiness to organize this important roundtable together with the Council of Europe. Hosting so many guests from abroad is a challenge of its own, and our Kazakh partners have demonstrated once again how reliable they are on both substantial and technical questions, with this roundtable being a bright example of our effective and daily interaction. Our cooperation activities have been greatly facilitated since the last year by the joint program with the European Union on the promotion of the rule of law in Central Asia, and I seize this opportunity to extend my warm greetings to Ambassador Jankauskas. Congratulations, Ambassador, on your recent appointment to Kazakhstan. And I would also like to thank the European Union delegation in Nur-Sultan for our close partnership in this region. Let me say a few words about the added value of the Council of Europe in this context. As you are aware, we are not only a pan-European institution, but also an institution whose effects extend beyond geographic Europe to cover large territory in Eurasia. And I think this element makes our cooperation with Kazakhstan and Central Asia even more relevant. Furthermore, and we emphasize this in all our projects, the Council of Europe is based on in-house knowledge in numerous legal fields and primarily in the judicial field. Our legal knowledge and our judicial craftsmanship are nurtured by jurisprudence of the European Court of Human Rights, which is complemented by the activities of expert bodies such as Venice Commission and the European Commission for the Efficiency of Justice, known as CEPEJ. And you see those bodies are very well represented at our roundtable today, so as to provide our interlocutors with valuable insights from both national perspectives and from Strasbourg institutions. I also see this roundtable as an outstanding occasion to enhance our cooperation with the Judiciary of Kazakhstan, most importantly with the Supreme Court, who plays a crucial role in the judicial reform. The relationship between the Council of Europe and Kazakhstan has been growing since the last 2 decades, but there is still potential for our cooperation to be strengthened. You know that Kazakhstan is party to 4 Council of Europe conventions. Kazakhstan is member to the Venice Commission since almost 10 years. More recently, Kazakhstan has become member of the Group of States Against Corruption, known as GRECO, as of 1st January 2020. The Committee of Ministers of the Council of Europe has approved in 2019 cooperation priorities for Kazakhstan, which extend until the end of 2022. So our event has to be considered in this broader context. We are convinced, furthermore, that our event will be beneficial not only to Kazakhstan and Central Asia region, but will also serve as a useful platform for exchange of good practices between different countries of the Council of Europe. Indeed, we have invited to this room experts and participants from at least 10 countries, and this makes our event a diverse and enriching source of inspiration. The event is being held in the context of Regional Central Asia Rule of Law Program, co-funded by the European Union and the Council of Europe. And despite all restrictions imposed by the pandemic, we started its implementation last year in all 5 Central Asian countries. And we are pursuing our activities as effectively as possible, and our event today, combining face-to-face with online presentations, is a bright example of our continuous efforts. I should recall that the program encompasses 3 main fields: facilitating the creation of a common legal space between Europe and Central Asia, and enhancing human rights protection, promoting transparency and action against economic crime, and promoting efficient functioning of state institutions and public administration. And it would not be an overstatement to say that we see our today's event, by its nature and extent, as an important step forward in the implementation of the current joint program. Indeed, the event will contribute to the achievement of the program's objectives in various ways. First, we will address the ongoing reforms in the field of administrative justice in Kazakhstan. Venice Commission has greatly contributed to this reform by providing its opinion on the draft law in 2018, and our event will allow to discuss the implementation of this code in the light of good national practices. Secondly, we will address two major ways of ensuring the efficient adjudication through IT technologies on the one hand, and through novel ways of judicial training on the other hand. IT in justice sector bring significant gains while also presenting challenges. Our experts from the European Commission for the Efficiency of Justice will share different perspectives on this topic. And as regards the judicial training, the Council of Europe HELP program is a leading cooperation model offering online tailor-made courses combining the domestic and international legal material. So there will be a special session tomorrow dedicated to the HELP program's activities. And over and above, we will discuss some highly topical questions relating to one of the fundamental prerequisites of the rule of law, that is the right to a fair trial. Respect of procedural safeguards in criminal proceedings is a topic covered by abundant case law of the European Court of Human Rights, which provides guidance and inspiration for legislative changes in numerous European countries and far beyond. And we understand the importance of this topic for Kazakhstan, and we were delighted to add this topic to the program in response to your, Mr. President, proposal. Ladies and gentlemen, dear colleagues, let me conclude my opening speech in Russian with a few words for our host and for the audience. Высокоуважаемый
Hi, distinguished Akip Kajmanovich. Let me thank you for your personal support of this joint event and for your interest in cooperation with the Council of Europe. I would like to thank you for your warm hospitality in Kazakhstan. Thank you for hosting our colleagues and experts, and I'm sure that the meeting today will become another important milestone of our cooperation. And moreover, it will provide additional foundation for our cooperation, the Council of Europe, that covers a wide range of issues which are quite significant in your legal system. Thank you.
A lot of following your proposal, I will also try to moderate in both languages. It is my pleasure to give the floor to His Excellency, Mr. Jankauskas Kestutis, the Ambassador of the European Union delegation to Kazakhstan. Please, the floor is yours.
Thank you very much. Спасибо большое.
Thank you very much. I will stick with our tradition. Distinguished Chief Justice, dear colleagues, experts, lawyers, sitting here at this table, on behalf of the EU delegation, let me welcome all of you at this event. I think we all missed our face-to-face communication, and it is better to sit here personally wearing masks and following all the safety and rules instead of communicating online, because having this face-to-face interaction, I believe, will help us cover more issues and exchange more experience and best practices, and get to know each other better during the next few days. I would like to thank our experts who managed to fly into Kazakhstan. It's not very easy nowadays, as you all know. I would like to thank our experts from the Venice Commission and from the Council of Europe for being here. If you don't mind, I will continue now in English.
A group of European ambassadors. Last week we went to Aktau, which is on the Caspian. We went to see students at the university, and we all asked the students who do study international relations what, in their views, in their eyes, the European Union is. And I was very pleasantly surprised when students said, well, some of them said very clearly that in their perception, European Union symbolizes peace, prosperity, democracy, and human rights. And none of that would be possible without the rule of law. These values and principles worked for us for decades, and we are open to share these best practices with our partners. And Kazakhstan is a very important global and regional partner for the European Union. We do share, based on our newly in place enhanced partnership and cooperation agreement, and in close cooperation with the Council of Europe, with whom we share much more than the two very similar flags, and with the Venice Commission, which is one of the most respected bodies in the field of the constitutional and legal support across the world. This high-level event is organized in the framework of the program called Central Asia Rule of Law 2023, jointly co-financed by European Union and the Council of Europe. This program is a concrete result of the commitment to support and accompany the ongoing democratic reforms in Kazakhstan, and to contribute, as it was said here before me, to the more efficient functioning of state institutions in Central Asia, in line with the best international practices. This program is demand-driven, and beyond national activities also includes an important regional aspect. As I understand that on top of us present here physically in the room, there are other representatives from the regional countries who are attending and listening online. This program provides a platform for an open discussion and exchange on equal footing with all Central Asian countries on the issues of the rule of law, based on common values and shared interests. I want to mention, Mr. Chairman, that Supreme Court is a major player in the process of judicial reforms. And I'm pleased to note that Kazakhstan reforms have already been undertaken in such important areas as quality of the judicial procedures, unified judicial practice, administrative justice, and professional qualifications of the lawyers. Today, the experts will focus on our discussions on the issues, important issues such as adversarial trial and equality of arms in criminal proceedings, the use of new technologies to improve the efficiency of the judiciary, as well as new approaches in judicial training. Let me thank all the experts, first of all, for making themselves available, some of them for traveling a long distance to be here, for their readiness to share the knowledge and the best practices. So thanks to Venice Commission, thanks to the European Commission for the efficiency of judiciary, CEPESH, and also the so-called HELP program, Human Rights Education for Legal Professionals. Once again, это мероприятие.
this event is the launch of our program, the program that is going to be implemented for the next couple of years, and I'm really glad that this coincides with the beginning of my work here in Kazakhstan. In my previous life, I, in my previous position, I spent a couple of years in Georgia, and in Azerbaijan. I'm really glad that I am gonna be working here in Nur Sultan, and I'm looking forward to next several years of fruitful cooperation. And I'm pretty sure that we will have a lot of common points of cooperation in the future, and we will gladly enjoy those achievements. I would like to wish everyone fruitful work and safe communications, and of course, distinguished chairperson, we are at your disposal. We hope for your support, and hopefully with your support this program will be even more successful. Thank you very much. Thank you, distinguished ambassador. Now I would like to give next floor to the chairperson, to Chief Justice Jakib Asanov. Please, the floor is yours. Thank you very much. Distinguished ladies, dear ladies and gentlemen, I would like to say that we are very pleased to take part in this roundtable. We missed these kinds of offline or face-to-face meetings, and what made this roundtable possible? Well, first of all, I would like to thank the representatives and experts of the Council of Europe, of the European Union and Venice Commission, because thanks to great organizational work, this event became possible. And we appreciate and we highly value those relations that we managed to build with each other. And indeed, we have a lot of ideas, insights, projects in mind, which we have already implemented and which are in progress or reflected on the agenda. So taking advantage of this opportunity, I would like to congratulate you, Your Excellency, on your start of work here in Kazakhstan, and I would like to express our willingness to cooperate with you. The EU and Kazakhstan have common history of very fruitful cooperation. Each meeting, each event of this kind helps us be on the same page with regards to global trends in the field of justice, and as it was already said, within the framework of this roundtable, we will have 4 sessions, and each session has a huge priority for all of us. Adversariality in the criminal proceedings. I think that at this stage, at the current stage, this topic is topic number 1 for Kazakhstan. Why is it topic number 1? You all know that the criminal proceedings conditionally can be divided into 3 stages. That's the pre-trial investigation, everything that happens before trial, then the litigation itself, as well as the execution of the sentence. And of course, for every country, for every society, it is important to resolve crimes. It is important to collect evidence. And last but not least, it is really important to ensure criminal punishment. But nevertheless, we need to admit that the key element or the hype of the criminal proceeding is the litigation itself. That's when a judge of the first instance considers a case. And today we would like to discuss with you the following question: how to make this litigation as much objective as possible so that our society was free from accusatory paradigm, and that's the chronic heritage that all of the post-Soviet countries are dealing with. However, I would like to say that in Kazakhstan, in recent years, something is changing. Is something changing in Kazakhstan in terms of overcoming this accusatory bias? Let me provide two brief examples with two time periods. So, I'm talking here about very serious and very serious crimes, and if you look at this slide, you see that the number of persons acquitted under grave and especially grave crimes, it increased by 8 times, and these persons were acquitted in 2018 it was 167, in 2019 it was 210 people. We see that increase, 18 times increase. As regards the complaints against the investigative bodies and prosecutors, we've created trial courts, and you can see that the situation is changing because the number of complaints against investigation and prosecutors have changed. These are more figures about sanctions for detention. Here, there is a twofold increase, but are these figures indicative of successes as a result of the reforms? Of course, no. The figures do not matter. What matters is the perception of the society, the perception of justice by the society, and we need to admit that the perception has not yet changed significantly because people do not really see how the prosecutors or the investigative bodies work. They do not see the execution of the sentences, and all of these stages of pre-trial investigation, execution, or litigation are not available to the society. People attend open trials, open hearings, and they see how the main litigation is going on. However, they can hear what the prosecutors are talking about, as well as the attorneys, defense attorneys or judges. They see the emotions of those people who are affected by these processes. Bloggers, victims, relatives of the convicts keep writing posts on it every day on social media, and every day we see the adoption of 5,000 final decisions, court decisions, and less than 1,000 sentences and decisions are made under criminal cases. And people in desperation ask a question: why nothing is being changed in Kazakhstani courts? Why our judicial proceedings are different from the proceedings in developed Western countries? And experts respond to that in the following manner. The reason is that the punitive syndrome of investigation still permeates all the courts, and the main litigation remains the same. Organizational measures do not really change the situation, and right now we have two opposite opinions. On the one hand, that's the opinion of the Supreme Court, because as it seems to us, as a specific or drastic measure that could provide an immediate effect would be the following. The judges shall not receive all the materials of the case at once. It needs to look at the they need to look at the defense acts and accusation. The courts need to receive the case or the case materials in a way presented by the prosecutors. But the goal of the prosecutors is to convict a person, and in that case, the judges become, let's say, dependent on the materials that are provided with the reflection of the vision of the prosecutors. That is why, in the eyes of people, our judges seem to be as the sources of punishment. We did not come up with the punitive acts. The EU countries, the OECD countries used to stick with the same principle, but such it's important to ensure um, the fact that the judge is unbiased and has an opportunity to get an unbiased information about the case. Of course, that requires the set of legislative and organizational issues to be resolved, and there are a lot of nuances, and I just don't have an opportunity to talk about all of them. I'm just mentioning here the most critical issues. Hopefully, our speakers today will cover everything, but we understand that introducing such a format of litigation will not happen in one night, and it shouldn't happen in one night. It will take at least several years of preparation. We need to train prosecutors, attorneys, and the judges themselves. And this position that I'm talking about is being defended only by us. As for other structures, they are against. The investigative bodies, as well as the prosecutor's office, are against, and even attorneys during the discussions do not support this vision. We even have the draft law, but we cannot facilitate that draft law because the key stakeholders are against it. Why do they stick with that position? Probably the opponents realize that it will result in more work, hence higher responsibility. Now it's easier for a prosecutor to convince a judge who studied the materials of the case before the trial, who is aware of all the nuances, that the person is guilty. But if we stick with our vision, then the prosecutors will have to start clean slate, and they will have to convince the guilt in an open and transparent proceeding. The attorneys will have more challenges as well. They will not be able to tell their clients that the decision was actually made before the trial, which means greater responsibility imposed on prosecutors, on attorneys, and on judges as well. The litigation is the final arena where defense needs to act in opposition to the accusation, and the new format of state litigations, in our opinion, will change the entire criminal proceeding. It will provide a multipliers effect. The investigation will collect evidence in a more quality manner. Otherwise, the prosecutors will not accept them. The prosecutors will prepare their motions and defend them during the trials. The attorneys will have to prepare as well because they are on the same equal footing to defend their positions in courts. A judge will be very free from the accusatory bias in that case. At the courtrooms, each party will publicly prove that their arguments are more reasonable and more convincing. That's the reality of adversariality rather than the declarative adversariality. And when the society observes such processes, it will have less questions to the fairness of justice. Of course, other ideas can be proposed in this regard, but one thing we know for sure: the main litigation shall not remain as it is right now, because it's been like that since the Soviet period, and it can no longer be the same way. I'm sorry that I'm trying to draw your attention to this topic in my introductory speech. We will have a lot of other important issues covered during the sessions. For example, the issue of administrative justice in Kazakhstan is very critical for the state apparatus and for the judiciary. It's a big challenge. We have been working under these conditions for 4 months already, and in 4 months, the courts said that more than 50% of the acts of the government bodies are illegal. We see the potential of the administrative justice, and we know that it can change the discipline of our state officials, improve their competencies and responsibility. And the most important thing, the administrative justice can protect the human rights from the state machine, let's say. The third session will be devoted to the promotion of CPESH standards and technologies used for that. Kazakhstan has joined CPESH in 2018, and we were a part of its review in 2020. And today we see our parameters, the parameters of our judiciary compared to the countries of the European Union. And we're sure that this will help us define the vectors of the judicial reforms. The fourth session is devoted to the judicial training for judges and legal professionals. All of these 4 sessions are extremely important. I would like to wish everyone fruitful work. Thank you for your attention. Thank you very much, Chief Justice. Not only you provided your welcoming remarks, you also provided a lot of details. Let's say it was a good detailed introduction to our roundtable, and I think that right after your speech, we will switch to our first session that is devoted to adversariality of the criminal proceedings. So we will finish our introductory part, and now I would like to give the floor to our moderator, Mr. Aslan Sultanovich Tukiyev, the judge of the Supreme Court of the Republic of Kazakhstan. Thank you so much, Sergey. I'm very glad to welcome you. Dear colleagues, unfortunately, the restrictions, let's say, diluted the density of experts in this room. A lot of people are attending our roundtable online. That is why I would like to say that our event is being broadcast on YouTube. It's being streamed on YouTube, and moreover, we have the judges and other stakeholders attending our roundtable. They can pose questions to our speakers, and I would like to welcome all of our online participants. Jakib Kazmanovich, in his speech, actually touched upon the topic of our first session. This session is devoted to adversariality in criminal proceedings, and it's about the indictment model and defense in courts. And it's a non-trivial process because the Criminal Code of Kazakhstan has Article 23 that presumes the presence of adversariality at all levels of criminal proceedings, or at all levels of the cycle of criminal proceedings. But we all understand that this inclusiveness is foreseen. However, when it comes to judicial stages, there are certain questions to take into account. Article 23 actually covers 3 aspects. That's adversariality, equality of parties, and division of functions. And unfortunately, the relevance of this dispute actually sends some signals that we have some problems in Kazakhstan under all 3 paragraphs of this article. So without taking your time, I would like to list the keynote speakers at this session. All of them will provide their presentations in the Russian language. I would like to give the floor to our first keynote speaker, who is attending this roundtable online. This is Pavel Petrovich Goncharov, the judge of the Criminal Cases Division of the Tallinn District Court, Appellate Court, and he's going to talk about the adversariality of the criminal investigation based on the Estonian example. Good day. First of all, I would like to know if you can hear me well. Could you please confirm that you can hear me? We can hear you. Okay, thank you. Dear participants of the round table, distinguished Chief Justice of the Republic of Kazakhstan, and dear representatives of the European Union, Council of Europe, Venice Commission, dear colleagues, it is a great honor for me to speak at this serious event. I was asked to talk on this event not long ago, that is, a couple of days ago, to be more precise. Unfortunately, I didn't have a chance to fly to Kazakhstan, even if I wanted so very much. I would like to be there in Kazakhstan and take part in the meeting of the International Council under the Supreme Court of Kazakhstan, a member of which I still am, but for the time being, I apologize for not being able to attend this roundtable personally, and due to the time limit at this session, I will try to provide brief presentation, and it was quite difficult for me to find this time to attend the session. After this short introductory remarks, I will switch to the essence of my report. I apologize for being maybe very brief or short, but I will try to stick with the time limit. It is really difficult for me to add something to what has already been said by Jakub Kazmanovich with regards to the relevance of this topic. And let me try to start the screen sharing in order for you to see some of my thesis. I support those principles that were voiced by Chief Justice. Estonia is a good example of that very country of the continental law that actively uses the principle of adversariality in criminal proceedings and adversariality of the judicial hearings or litigations. And I would like to, first of all, say that those changes that we have planned and those changes that are being supported by the Supreme Court of Kazakhstan indeed had a significant impact on the increase in the role of the prosecutor's office in the process of collection of evidence at the pretrial stage. And at the same time, they improve the role of a defendant, both at the pretrial stage and during the trial. The judicial or the pretrial investigation is going to be separated from the trials in order to improve the unbiased position of the judges. That will improve the adversariality as well as, and that will enhance the right of a convict to defense. When I was preparing this information, I shared the slides with the organizers. I don't know if it's possible to share the slides with you, or it will be easier for me to share my screen. What do you think? Could the organizers share the presentation, or should I do it myself?
Colleagues, anybody? Our technical team? Okay, not to waste our time, I think I will share my screen and start presentation sharing now. Can you let me know if you can see my presentation on the screen? If the question is about your name on the slide and black background, yes, that's what we can see. If it's something else, then we don't see your slides yet. I started sharing my screen, And just a second, now we will put your presentation on the screen. Yes, you started sharing your screen. That's great. Can you see it now? Okay, thank you. Thank you. Apologies again for this technical hiccup. It would be a lot better and more convenient to be in the audience with you. Uh, but just to share my position on several issues mentioned by Mr. Jakub Kozmanov. And during the preparation to this roundtable, I was informed that the prosecutor's office and investigation authorities currently do not support Supreme Court's proposition, which are based on the dual assessment of evidence, and that the evidence will be shared for the first time during the trial. Prosecutor's office in the Republic of Kazakhstan, and their position is that adversariality of the litigation is as it is in the Anglo-Saxon law. Therefore, it cannot be used in the common law countries. As for this criticism, I cannot agree with that. In the condition of dynamically developing and evolving world and globalization of the hybrid forms, in order to increase the efficiency and accessibility of justice. Currently, we are changing the legal paradigms both for common and English law. And today's litigation proceedings, the trial procedures, is dominated by the judicial positivism when the government puts such a procedure which is being held as relevant to ensure rule of law and to serve the interest of protecting interests and rights of the citizens. Today's model in Estonia can be called hybrid, which unifies both models of inquisition and adversarial proceedings. Estonia was not the first country in continental Europe which introduced elements of the classic English adversarial proceedings. The first country was Italy, which used this hybrid form for trial proceedings with a very big very big focus on the adversariality, with the new procedural code, which was put in effect in 1988 and was effective from January 24th of 1989, and that's actually replacing inquisitory criminal proceeding. The new model in Italy is characterized that it has clearly defined pre-trial inquisitory proceedings and the litigation, which is adversarial. And actual prosecutor's office is responsible for investigation and is responsible for the full-fledgedness and completeness of investigation. With provision of sufficient evidence of accusation, and also providing evidence if there is something for defense side. Following the Italian procedural code, it was the so-called investigatory judge. I am sorry for bad Italian pronunciation. Apologies for that. This is injustice in this is GIP called GIP. Which actually looks at the legality of the pretrial investigations and puts some limitations on the rights and freedoms of the defendant. Today, both such provisions are in Estonian and Kazakhstan legislation. Italian model is also characterized first it's evidence-based, which evidence are provided at the end of the inquisitory pre-trial proceedings, and provision of evidence to the court, and the development of the materials and evidence during the adversarial litigation. Therefore, Italian system is hybrid form of inquisitory and adversarial models. Hybrid with two specific divided stages of pre-trial inquisitory and the second litigation adversarial proceeding, and it is also in Estonia. This is the case starting July 1st of 2004, when when the new procedural code was made effective in Estonia. Apologies, I went too much ahead of my presentation, too many slides ahead. So let me go back to the first slide. This is the second slide. Thank you very much. I can see that I'm not controlling my presentation now. It is being controlled from the by someone from the technical team. Yes, it is being controlled from our board. And the second slide, I would like to bring your attention to the moment. Just a little bit of statistics. If we look at this topic today, what we are interested in the litigation in Estonia, it's called general litigation. If we look at the statistics, and we will be able to see 7.5%. 7.05%, that is adversarial process we are interested in today. Other criminal cases are sent by the prosecutor's office to the court after pre-trial in other alternative forms of proceedings. Today, adversarial classic form of a trial is being applied in Estonia with some variation from year to year, from 7 to 10% of the share of cases coming from the prosecutor's office to the court. As for other forms of procedure and proceedings, you probably are aware of that, in particular Western experts who will be speaking on that topic after me. We know and in the statistics, more than 70% of cases we had in the court and were resolved by the courts of the first instance as the this is a procedural agreement. If we are speaking about such, then the trial itself, the litigation itself on such cases is not being done. So majority of the evidence and materials are being provided, and the agreement, which was pre-drafted and actually made before the prosecutor, defendant, and the legal defense, and the court can disagree with this agreement. It can send it back to the prosecutor's office. And as for the agreement proceedings, at least in Estonia, it is not possible to have the sentence. If a court disagrees with the agreement, it provides its motivated resolution, and this case on the a green proceeding is sent back to the prosecutor's office. And the next form, when all the evidences and materials of the case are submitted to the court, and it is the limited proceedings of the criminal code, where it is summary procedure, where again the sentence cannot be in the form of detention and of a lifelong detention. Also there are the grave articles for grave offenses, if defendant does not agree to the summary procedure, his sentence can be shortened 1/3. Even though it is an oral trial, as written evidences are being submitted, this inquisitory proceeding, and the defendant can make a motion not to provide any statements, but if such motion is not made, then motions can be taken into account. It is also about some monetary punishment for some criminal offense. What we are interested in today, this is actually as a general litigation adversary proceeding, which is here in 7.05%, and it can go up to 10% in some years. When such cases come to the court, it's very often that during the preparation of the litigation, at the preliminary trial, at the preliminary hearing, parties make motions that they are ready to move to other forms of proceeding summary procedure, or they announce their readiness that they are ready to sign a procedural agreement. Also, I would like to highlight such a fact which directly touches upon the adverse proceeding. If you look at this diagram, at this graph, and if you look at the total number of the cases in Estonian courts, the defendants are acquitted only in 1% of all cases. But let's take into account that the acquittals are not actually possible if people are well informed and they go to the procedural agreements and agree on and to accept a deal on the punitive sentence. It is possible only in the general trial and also in summary proceeding. If we look at the number of the acquittals there in the summary proceedings, again, this is one type of the inquisitory process. It is 1.5%. Other 6.5%, they are in the adversarial proceeding. If defendant does not agree with the sentence and wants to fight till the end, this is possible, and he or she can disagree with any suggested and offered by the law possibilities to go with the inquisitory proceeding. We can go to the next slide, please. And as I mentioned earlier, in Estonia we have the system of two materials, or two evidences. And it's in addition to Estonia, it is available in Italy. Only the motion of the prosecutor's office goes to the court, and then the parties provide their evidences. Let's look how it is happening, what kind of possibilities parties have at the pre-trial stage, and how this is being considered in the court. So, as for the after the pre-trial stage, prosecutor's office says that the pre-trial investigation is over, and then the case materials go for a study, for getting acquainted, as these materials go to the defense attorneys only on motivated motion. These materials are submitted in paper and electronically as a rule. Soft copies are being provided, and the key difference with Kazakhstan is that defense attorney provides all the materials and get the defendant acquainted with them. If a defendant is willing to get acquainted with these materials. If he or she is not willing to get acquainted with this evidence, a corresponding certification letter is being provided to the defense attorney. And then a motion is submitted. Prosecutor's office can give specific time frame to get acquainted with the case materials if they have a sense that the time is being intentionally prolonged. After all the motions will be submitted after getting acquainted with case materials and evidence, prosecutor's office draws their action. And I read about the criticism towards the prosecutor's office that judge can become biased even after reading the prosecutor's action. I will not agree with that, because nowadays, following Estonian legislation, the prosecutor's action and what Kazakhstani colleagues received a copy of our criminal procedural code, and colleagues, they know a lot about our criminal procedural code, and the Supreme Court also had a study visit to Estonia to learn more about our adversarial procedure in action, and also participated in trials. They were observing these trials, and prosecutor's action is drawn that way that it provides, the prosecutor's office provides a list of evidence to actually support their position, but it's not about the evidence itself in written form in this action, but only indicates what actual positions of the investigation team. It provides actual evidence. It might be witness statements or defendant statement, or the victim statement. There are no judgments or opinions of the prosecutors or investigators. It's not included there. It's only the list of evidence, and in the list of this evidence, there is actions which are being provided by the prosecutor to support the specific position. And therefore, during the study of by the judge of this action is not making judge biased or impartial. And after the prosecutor's action with the support materials, with the evidence also about the sentence, and the list of persons as witnesses, and before the defense action, before the pre-trial hearing, this defense action is being submitted. It is the actual position of the defense in terms of the prosecutor's action, and evidence from the defense attorneys providing evidence for the specific positions, and also the list of witnesses being served for these hearings. And based on these two documents from the defense team and the prosecution team, the preliminary trial is obligatory. And at these preliminary hearings, motions are being considered of both parties about additional witnesses which were not indicated in the actions submitted by the prosecutor's team, and defense team can submit additional motions. I would like to indicate that why we are not considering evidence and motions which were submitted in the prosecutor's action, because if prosecutor's office says they are relevant and submitted as the materials of the case, then they have to additionally collect materials, and it will include them into the prosecutor's action.
If the prosecutor's office does not agree with that, then this motion could be repeated at the preliminary trial. Also, at the preliminary court hearing, we look at the issues indicated in paragraph 3 of this slide. So next slide. When the court allows these motions, it issues a decree on satisfying or not satisfying these motions related to the planning of the court hearing. Sometimes this can be done with the court. This can be, but not necessarily. This must be related to the preliminary or pretrial court proceeding. All of the motions are processed and accompanied by the additional decree on the case, which usually is appealed in an official manner when the parties want to file an appeal regarding the court decision. And the investigation is decided at the session, and according to the law, if the case is not very big, let's say it's a minor case, and with only 2 witnesses, then the prosecutor invites these witnesses to the court hearing, and the investigation in an adversarial manner may become the continuation of the preliminary trial. But as a rule, that happens in exceptional cases. And the litigations with regards to the convicts usually take place only based on the indictment and based on those factual circumstances which are indicated in the indictment. With the support of the indictment, neither prosecutor nor the court have the right to refer to those evidences that have not been provided at the court hearing or have not been studied by the judge. And that's what Article of 268, paragraph 5 says about. And you can see the wording of this article on the screen. Next slide. So how does this study of the evidences look like? First of all, the evidences that were provided in the indictment of the prosecutor are studied thoroughly, and then they are continued by the study of the evidences provided by the defense attorney and other parties to the hearing. But the parties can agree on a different order of consideration of evidence. Next slide, please. The court accepts only those evidences or collects those evidences, and here I would like to emphasize that the process itself looks as dispositive, and the court has some opportunities or possibilities that prescribed have the possibilities to independently collect additional evidences regarding the case. For example, the court can launch the expertise in case it is required by the case and neither of the parties filed a motion with regards to the collection of additional evidences. And additional evidence collection is initiated by the court usually, and it's more like an exceptional measure in case the parties do not come to an agreement on the verdict of the court. In our legislation, in our judicial practices, if, for example, the party itself did not file a motion regarding additional collection of evidence, then in no way the evidence is collected by the courts uh, can serve as the basis for the cancellation of the verdict, and it's not also considered as the violation of the criminal law because parties, in the first place, the parties are supposed to provide their evidences at the courts, and during the investigation at courts with the principle of adversariality, they need to use the principle of disposition. I think that you looked through this article and see the main terms of accepting evidences at the court hearings. Now let's look at the statistics of the prosecutors on the procedural decisions. When studying all of the evidences, it's quite typical for the Estonian courts and maybe for the Anglo-Saxon law, the interrogations of the convicts or victims as well as witnesses, according to our criminal procedural code, are held only as the cross-interrogation, which means that the witnesses, convicts, victims do not have the right to bear a testimony in a free manner, which means that the party that is that provides the sources of evidence, for example, if this is a victim or some witnesses, then they start the cross-interrogation first, whether this is the interrogation of a witness. And during the primary interrogation, what's the cross-interrogation? During the primary interrogation, it's not allowed to ask some lead questions. The opposite party in this case, or the defense, has the right to ask some lead questions, but only in those parts where some evidences have already been provided or some testimonies of some victims have already been given. And the court in that case has the right to ask questions at the very end. And it should be noted, though, that after secondary interrogation, the right to ask additional questions regarding what has already been said can be provided to the opposite party, but eventually the courts are the last ones to pose their questions. And when the court, when considering a criminal case, sees what evidences or what actual circumstances require having additional or asking additional questions, for example, if the testimonies of a witness do not provide any significant information, then the courts can double-check the authenticity of the testimonies of the witnesses. What if a witness changed his or her testimony and the court does not really know what were the previous testimonies of a witness? In that case, the party to a case, and I think I talked about it already, the party to a case, whether this is the prosecutor or the defense attorney, needs to know that the testimonies have been changed, as a result of which a motion is filed in order to double-check the authenticity of the testimonies of a witness. And only that part of a testimony is voiced out. That part has been modified by a witness. The part that has been modified by a witness is voiced out in order to indicate what actually has been changed in his or her testimony. As regards the assessment or evaluation of the evidence, in case the testimonies were changed, the prosecutors and the court tried to find out the root cause for changing a testimony. And if this happened because a person just forgot or the event took place long ago, and if a witness does not really remember everything, then the court may not even accept such a testimony, saying that these testimonies are not true or authentic, and the courts may not take into account these testimonies when assessing all of the evidences. And when the judicial proceeding is over, judges in Estonia, just like the judges in Italy, in case there were some other circumstances related to the case which remained uninvestigated, then in exceptional cases, the judges of Estonia, just like the judges according to the Italian Criminal and Procedural Code, have this right to collect their own evidences, and as a result of which they come up with their verdict. That's how the principle of adversariality works in Estonia. I would like to reiterate once again that the real adversarial proceedings are applied only with regards to those categories of cases where the defendants want to prove themselves innocent, or when the prosecutors insist on certain types of punishment which can be excluded in alternative dispute resolutions or alternative proceedings. And our criminal procedures, both at the pre-trial stage and during the trial stage or during the litigations, are still inquisitive in nature. Therefore, the Estonian system can be fairly called a hybrid system of criminal justice. In conclusion, we see on the screen the slide number 10 that provides the statistics of the prosecutor's office on procedural decisions after the end of the preliminary or pre-trial investigation. We actually started with those cases that are considered by courts, but if you look at this slide, you see that the prosecutor's office itself sometimes do not file an indictment and stops proceeding on its own without punishing an individual, but with a proper imposition of measures of criminal and procedural impact. That means paying some judicial fees or damage fees, or that means community work. The prosecutor makes such decisions on the cases that are received by the prosecutor's office with regards to individuals who've been convicted for the first time, and sometimes the prosecutor's office at its own discretion stops the investigation, and the preliminary average or the estimate is about 40% of cases that are shut or closed by the prosecutors at the preliminary stage, at the pretrial stage. And as you can see, about 40% of criminal cases do not reach the courts of Estonia, and that's explained by the fact that certain criminological surveys were held and the rate of reoffense of individuals who remain unpunished were identified. So, in those cases, the prosecutors think that the rate of reoffense is very small, hence the individuals who were convicted have a higher probability of not recommitting the offenses again. For now, my presentation is over. I'm ready to answer all of your questions if there are any. Thank you so much for your attention. Thank you very much, Pavel Petrovich. Of course, we have questions, but according to our agenda, we will have the questions and answers session for this purpose. Thank you so much for having a deep dive into the law enforcement practices of Kazakhstan. I would like to remind you of 10-minute time limit. I will be very grateful for sticking with the time limit. I would like to give the floor to Murat Chekishevich Kogamov, the director of the Research Center on Criminal and Procedural Surveys and Countering Corruption of Kazgiu University. He's going to talk about the Criminal Defense Act in a criminal case, stages of development and consequences. Thank you so much. Dear colleagues, the judicial reforms are going on, and during the years of independence, Kazakhstan had reached a great progress. For example, we can look at the recent case. In September of last year, under the Security Council of our Republic, the special working group has been created, and I'm the member of that working group. We tackle serious questions there, mostly related to those abstracts that the Chief Justice of the Supreme Court mentioned in his speech. Of course, we see some significant impulses. However, as a working group that works under the Security Council Secretariat, report on all of those things at a higher level, on a level of the President's office that runs the Commission for the reforms of the law enforcement and judiciary. So the head of the Secretariat of the Security Council, as the member of the Council for Legal Reforms, supervises this work together with the head of state, implementing lots of things that have been developed on the level of law enforcement. And we've considered a number of draft projects which are being now submitted to the lower chamber of our parliament. We act there as experts, actively taking part in all of the discussions, and we discuss the laws related to the criminal construct of our proceedings. So for the purposes of proper simultaneous interpretation, I would like to read out my report that I have prepared for this event. So it happened that the human activity is always measured by something, and human activities in the field of criminal justice or proceedings are not an exception. In criminal proceedings, as a specific type of state activity in combating crime, three main functions have been put forward, formalized, and are in operation. That's accusation, defense, as well as resolution of the criminal case on the merits. Moreover, the bearer of these functions, as part of the main ones, are the bodies conducting criminal proceedings and other participants. And this is what we see here. Activities before court or pre-trial activities, activities outside court and for the court are mainly represented in the court itself by the prosecutor's indictment, which is based on the materials of the criminal case. And the courts in this regard are forced to work within the corridor set by the criminal prosecution authorities and the prosecutor. Formally and legally, this is correct. But if you look at the fact, such legal relations connect the courts with the materials of the criminal case formed by the criminal prosecution authorities.
That is, in certain sense, they make him and all the participants of the trial their hostages. The situation is aggravated by the judge's lack of reason tried to collect additional evidence in a criminal case, as well as the right to return the criminal case for additional investigation. I will not go deep into details. Why is that happening? It's not difficult to guess how this connection between the judge and the material of the criminal case ends for the defendant. That is why the thesis actively put forward by the Supreme Court of the state and chaired by me, that the prosecutor sends an exclusively indictment to the court without the materials of the criminal case will undoubtedly become one of the factors of the real adversarial structure of the criminal proceeding. In this order of affairs, first of all, it will radically increase the efficiency of pretrial investigation of criminal cases and prosecutorial supervision in this area. In my opinion, prosecutor will be in the case from the moment of admission and registration of the complaint. The court, in the context of a trial, will simply be obliged to deeply and accurately examine each piece of evidence cited in the indictment, using the forensic methods of their investigation. Along with the above, such a structure of moving a criminal case to court will be clearly illogical and objectively require for its harmonization, equalization of the potential and legal personality of the parties of the trial, a significant revision, in particular the activities of defense attorneys in the criminal proceedings. In a word, if there is an indictment in court, then there must be an act, an act of defense of a defense attorney at the same time. What do we have today in pre-trial and in litigation instead? A competent attorney as a rule conduct a parallel case dossier in certain sequence and order in which it concentrates all the necessary procedural and actual papers in the criminal case. This dossier is not disclosed in the full in court. There only has actual materials necessary for the relevant judicial investigation and pleading of the parties are used. Moreover, the speech of the attorney in the argument of the parties is not always flawless and evidential. Moreover, the defense attorney does not always resort to transfer to the judge before he leaves to the deliberation room the written wording on the first 6 issues that the court clarifies in this room when deciding the verdict. It is precisely the key motives that require the introduction to the criminal proceeding an independent procedural act, the act of defense. What circumstances are conducive to this today? First, legal practice in the field of criminal procedure has a long history. It has developed its own approved standards of behavior for attorneys in criminal proceedings. In other words, the transition to the act of defense will be a natural fact and will be continuation of the improvement of attorneys' practices in criminal proceedings. Second, this is as a legal foundation that created the conditions for the implementation of this act of protection, of defense. So, according to the law of the Republic of Kazakhstan dated June 9, 2021, which significantly expanded the methods of work of defense attorneys in pretrial criminal proceedings, a lawyer is now entitled to get acquainted with a certain list of procedural documents already from the moment of joining a criminal case as defense attorney, to cut or to receive from the person carrying out the pretrial investigation during the entire investigation copies of the decision of the pretrial investigation body and the criminal procedure code in relation to his client. At the end of the pretrial investigation, to get acquainted with all the materials of the criminal case, write out any information from it in any volume, make copies using scientific and technical means. And the last position was always in place. Already from this, it's obvious that the attorneys during the investigation of criminal case accumulate a certain amount of procedural information which can be effectively used to develop an act of defense. Third, in the course of the defense, an attorney uses of such tools as complaints, petitions, and various subjects of criminal procedural activities, submitting motions with obtaining answers from prosecutor's office. By the way, this is additional motivated material for use in the future act of defense. Fourth, complete set of information defense attorney gets after the end of investigation during the period of familiarization with its materials. This is also a weighty basis that finally forms his or her opinion on the need to develop a coherent act of defense in a certain context. Fifth, in general, I do not recommend revisiting the methods provided by the Criminal Procedure Code for obtaining evidence by defendants. We have 2 key articles in the Criminal Procedural Code where these methods are described in detail. They are quite enough for conducting active proof of certain circumstances of the case. There is no need to turn an attorney into an investigator. I have given 5 most important reasons for introducing an act of defense in the criminal proceeding. And now about some of the details of the defense action. First, it should be a development of this action should be right of the responsibility of the defendants. Second, due to the indisputability of such cases, the defense action may not be developed in the cases of order protocol, accelerated pretrial proceeding, as well as those ending with an agreement on the admission of guilt. Third, the content of the defense action mainly should not be focused on the analysis of compliance with the principle of comprehensiveness, completeness, objectivity of proving the circumstances of the crime during the investigation. On bringing the arguments of the defense to refute the suspension accusation, as well as the quality of verification of these arguments by the official investigating the case. It is also important here to indicate how the investigator reacted to the complaints, petitions, motions of the defendant, including those addressed to him to the head of the prosecutor's office and investigating the judge. If we are being listened by the practicing judges, I would like to bring your attention to this detail, dear colleagues. We should always pay attention on how investigator reacts to those resolutions made by the judge in supporting attorney, for example, on different aspects of the investigation. This is your colleague, and you should react properly and assess, evaluate level of the competence and responsibility of the prosecutor and the investigator, depending on the decisions which were done a lot in advance before the trial. If the for the time of filing such an action should not coincide with the substitution of the indictment to the court. The lawyer, an attorney should have reasonable time. Fifth, the defense must be filed with the court before the case is prepared for hearing by the court. It is this stage that such an action can change the future movement of the criminal case, for example, lead to its termination. We have a detailed description of the pre-trial stage. This stage is it is obligatory for extremely grave cases and for other proceedings as well, and therefore such availability of the defense action might have an impact on the opinion of the judge. Six, the defense action must be, in all cases, be announced in court. Traditionally, first goes the accusation team, and then prosecution team, and then it is witness statements and so on and so forth. But what my suggestion is that the defense action should be also provided after evidence is provided by the prosecutor's team. We have actual procedure described for all, both for defense and prosecutor's teams. And if we follow such procedures, this is the second document, which brings new nuances to the litigation, and the work should be done after who is responsible by law and constitution to bring evidence, reports on the specific circumstances of criminal case. And the last but not least, what I would like to bring to your attention, this is a summary. What it will give us. First of all, the defense action will be concentration of the work of the attorney on the whole criminal case dossier. Can be several volumes. There might be soft copies of evidence in the criminal case. We have 1,500 or 2,000 volumes cases, and as for resolution for Khargos case, for example, we had on our border some time ago, it was investigated and considered correspondingly, and this big bulk of materials, it would be challenging to put it together in one box, and it is not possible to have it all the time with you. Therefore, the defense action will be something of a summary and the talent of a defense attorney to put such document together. And clients will be judging the work of their attorneys and defense team following the quality of such defense action. And it is a conversation between attorney and the client. This is also a talent to draw and write such documents. It is also identifying the passive nature of some attorneys. Prospectively, we believe that we will be even including such a regulation. It on one hand, we have this principle of the adversariality. And for example, in the United States, if this principle is not working, case goes back to the prosecutor. We should probably also think about that, about if the attorney is passive, is not fulfilling his obligation correctly, then case should go back to the prosecutor. And as a prosecutor, if any attorney have a deep dive into the case materials and evidence, then we will have a better quality defense, and it will be a serious opposition to the indictment. Since litigation is not just a repetition of the pre-trial, then a court will have a possibility to be objective in studying all the circumstances of criminal cases. I share just some key approaches on how I personally see defense action in our criminal proceeding. Colleagues, I can assure you that we will bring that into reality. We will make sure that it is going to happen. We launch the process. January 1st, we will have new legislation made effective. Work of the prosecutor with the investigation. We even created big law enforcement bodies, investigation committee, for example, and it is a great pleasure to see a chairperson of the Committee on Legislation and the Judicial Reform. He is head of the working groups on the termination of some of the practices, and also on improving some situations with other acts with the prosecutor's action, and how the defense action should be developed. I would like to inform the Chief Justice that the opposition to the defense action is that who came to this profession from other professions, who worked as an investigator in the past, or the prosecutor, or as a judge in the past. Therefore, they are opposing this practice because they know that it is serious, huge effort to work on preparing this the defense action. And it's not something which comes so easily. Thank you very much for your attention. Thank you very much, Marat. And I would like to tell our colleagues that in 20 minutes we will have an event with the participation of the head of state, where some of our colleagues should be present. They have to be there following the state protocol. In any case, we are recording this roundtable. We will see and we will watch presentation of all the speakers. At the same time, I would like to thank all of you and to wish you fruitful work. Thank you very much, Mr. Marat. Thank you very much for your presentation. You said that the defense action should be looked as right, and if the defense action is right, I don't see any principal objections, that it is mostly positive in terms of the defense team's effort. It will be an additional opportunity. I think we will discuss this issue in details later. And now, the floor goes to Mr. Vasily from the Department of Human Rights from the European Court. And Vasily, please, the floor is yours. Colleagues, greetings. I would like to start my presentation before our technical team will put my presentation on the screen. I would like to start my speech by saying that it's a big honor to participate in this roundtable here in Kazakhstan. As a person who was born in Kazakhstan, in Pavlodar, I spent my childhood and youth here. It is a very big pleasure to meet my Kazakhstani colleagues, and I remember as in 2004 I was participating in Supreme Court about reforming the civil proceeding in Kazakhstan, and now sometime after that we are discussing reforms in criminal proceedings. Can you put my presentation on the screen, please? Can you start my presentation? While technical team is taking care of that, I will start with my speech. It should be understood that yes, actually, the role of the European Convention in the EU member states cannot be overestimated, because it is some base for European rule of law. It should be also understood that we have 47 countries with different legal traditions, with different judicial cultures, with different organizations of the court authorities, and the standards which are developed on the conventional system basis, they are universally applicable for any potential judicial system within the Council of Europe. And the adversariality, as it is in the convention, it is very universal compared to the adversariality which we discussed previously. It is very important to understand that the standards I will be actually referring to in my presentation, and the standards I will be actually covering that you can read about in different publications, it should be understand and acknowledge that those are the minimum requirement for quality, and the means of implementation can be chosen by every government independently. It should be understood that every state, depending on its vision of values which persevere in this state, principles of judicial system, can choose different different means of implementation. Can we go to the next slide, please? Probably we cannot. Yes, this is the right one. So I will not still step aside from the discussion we have started, and in terms of the inquisitory and adversarial system, I think this is these are very common definitions, and there is no actual links to the ideal system, because ideal systems do not exist in any state globally, because all the systems they are hybrid ones. Yeah, the ones are more towards the idealized English law, and the others more about the common law proceeding, but in their pure way, they do not exist anymore. Basically, all the systems are hybrid in one way or the other. And a very important difference still should not be forgotten. It is the goal of the proceeding itself. The English law model means that it is it should be justice and a motivated resolution. But as for continental law,
in the Soviet procedural law, there was an obligation, but the modern post-Soviet procedural law for the majority of the post-Soviet countries says about the multifaceted consideration of all of the case materials as well as the study of all of the issues, and that's the reflection of the same principle when the court indeed needs to state what actually happened in the case. And the adversarial model, that very adversariality that we're talking about, does not really imply getting the truth. The court is just an arbiter that hears out and comes to a final decision that can be appealed. That is why there is no mandatory defense act in the adversarial model, because the defense decides itself what needs to be done. If the defense attorney decides that it will just sit at the board of jurors, keep being all quiet with his client, then from the perspective of the adversarial model, there is nothing problematic about that. It's okay to sit there and stay quiet. That is why the Defense Act as a mandatory element does not necessarily mean the adversariality of the process. It's just an inquisitive process. What that means that the parties are liable to help the judge find the truth, the truthful or the actual nature of the case, as well as the truthful resolution of the case. That is why we see all other arguments related to the court authorities to return the case back to the investigation stage. For example, the court can give the parties the order to collect relevant evidences or to carry out the relevant expertise. That's the property of the inquisitive process, because despite the hybrid nature of the system, neither American nor British judge would ever think about indicating what evidences the parties need to collect, because that's the adversarial process. Whereas when the courts give these orders to the parties about what evidences need to be collected, that's usually what is done by the German courts on a daily basis, but that's the very inquisitive process, or the continental process. And the German courts actually are supposed to find these truths according to the law by using such approaches as well. And this big discussion about the inquisitorial or adversarial models actually mean that after studying all of the evidences under the criminal case or during the court hearing, these discussions are more of a discussion about the truthfulness of the evidences. It's not about whether Kazakhstan should choose one of the models. And I would like to reiterate again, this is the discussion of the principle of investigation or study of the evidences as part of the judicial proceeding. And this principle could be implemented by using both of the models. However, it is really important to remember that this is not an integrated system or an integral system. So whenever we start thinking about how these evidences are going to be studied, well, we need to keep in mind, dear colleagues, that you have introduced the Institute of the Trial Judges that take part in the collection of evidence, and they also interact with the defense side. In this case, it's necessary to integrate the role of the trial judges into the entire system, and we need to think about the stages of admissibility of evidences or inadmissibility of evidences. So it's not about just integrating the indictments. It's really important to think through the entire system and procedural guarantees or safeguards that are going to surround this system. Let's skip one slide and move to this part, the adversariality under Article 6 of the European Convention. Here I'm going to be very brief because I'm already out of my time limit. It's really important to understand that Article 6 of the Convention ensures the right to fair trial. That's the exceptional procedural safeguard or guarantee of rights, and that's the and it's really important to realize that it's also the limited right. It's really important to understand this whenever you read some European standards or the decrees of the European Court. The main criteria used by the European Court, the main criteria under the European Convention is the overall fairness of the proceedings, and this fairness is assessed not on the basis of the specifics of the criminal proceedings. It's evaluated on the basis of effectively implemented rights prescribed by the Convention. And within the right to fair trial, lately, from the experience of the courts, we observed the transformation of the right to effective participation of the convict in the trial. Next slide, please. If we try to describe what the European Court and what the European Convention implies by the adversarial process, that's the rational opportunity to present one's position that can be compared to the position of the opposite party. So that's when the positions are comparable but not identical. The adversariality can be divided into two sub-laws, sub-rights, let's say. That's the right to know about all of the evidences and arguments provided to the court, and the right to express one's position with regards to these evidences. That's the right to make a comment, to argue any types of materials presented to the courts. Next slide, please, or provided to the courts. The right to know about everything. As an example, this means that the defense needs to have access to all of the materials and written arguments, regardless of the stage or the individual that provides the arguments to the court. And in some legal systems, there were some conclusions or so-called conclusions of the attorneys provided to the courts. Nevertheless, the defense, for example, never had a chance to look at the content of these conclusions or arguments. And when the defense does not have an opportunity to make a comment, the process cannot be recognized as adversarial. In fact, this right to know and this right to express one's position are frequently intertwined, but to a greater extent, the adversariality can be confined to these two sub-rights. Let's move to our next slide, our last slide. The most important thing here, I think that this is going to be the most important thing during the reforming of any type of legislation, and I double-checked my presentation from 2014 when I was in Astana in the building of the Supreme Court. I said the same thing. The decisive role in ensuring fair trial, in ensuring the observance of rights to adversariality belongs to courts. That is why whatever changes have been implemented in the procedural legislation, the courts still need to maintain this function to ensure the fair trial. That's very important, and this function is typical of courts regardless of system, whether this is an inquisitorial, adversarial, or hybrid systems. The courts need to be capable of controlling the proceedings, and the courts need to be liable for taking motivated decisions and for guiding the parties during the process. And at the same time, it is also important to have this broader discretion for the courts. The courts need to have this broader or wider discretion when taking procedural decisions, but that does not necessarily mean that the courts need to have specific international standards as well as the logics of arguments to stick with, because if we look at the Kazakhstani legal system, and if you decide that the objectives of the criminal proceedings is to find truth and to ensure multifaceted litigation, then you can fully implement the adversariality principle within your inquisitorial processes, just like the Germans do. And that's what every one in Germany does. Their processes are adversarial and inquisitorial. So Kazakhstan can decide to choose the English way, or and in that case you need to remember that each of your choices will imply not one or two procedural changes. Each of your choices will imply the deepest analysis of the reforms of the entire criminal proceeding system. Without this, you will deal with failures in the system, and you will see that the interactions at different stages of criminal proceeding will have its faults, which means that these problems eventually will have to be resolved anyway. But overall, I think that you can cope with this, and I'm really sure that the Kazakh land has a lot of talents, a lot of professionals. That is why our modest support, I believe, will be somewhat useful to you. Thank you so much. Thank you very much for your presentation. I also try to be brief, but since we are behind our agenda, I suggest that we move on. I would like to give the floor to the judge of the Supreme Court, Gulnara Jaksalikovna Mirgenova, who is going to speak on the adversariality in criminal proceedings. Thank you so much, Aslan Sultanovich. Good day, dear participants of the round table. The previous speakers expressed their opinions regarding the model of Kazakhstani proceedings. I won't take your time. I will focus on main areas only. So the question of how this adversarial principle is actually observed in criminal proceedings of Kazakhstan is important not only for our colleagues, it is important for the international colleagues as well. Lately, the criminal and procedural legislation laid down a number of norms aimed at ensuring the balance of the parties and creating a mechanism for ensuring adversariality. These novelties were aimed at strengthening adversariality, and the attorneys or lawyers were provided broader authorities. I'm not going to list all of them. Nevertheless, to say that the parties in criminal proceedings are equal is premature, because the prosecutors and the attorneys are not on an equal footing, and that includes the resolution of the case by the courts. So what do we have? We have a fully formed prosecution of the criminal case that enters the court proceedings. That is why the courts very frequently form the accusatory bias, because they already have the evidences prepared by the plaintiffs. The lawyers lack the authority to collect and present evidences at this stage of the pretrial investigation. The role of the prosecutor remains dominant in court proceedings. Judges, when making decisions, rely to a greater extent on the evidence presented by the prosecutor. At the same time, I would like to say that the prosecution is supported by the prosecutor's advisors who did not supervise the criminal case during the pretrial investigation and who did not study the materials of the case. Therefore, the judges often are forced to interrogate the parties to the process, causing suspicions with regards to the accusatory bias. As regards the roles of the lawyers or attorneys in the criminal proceedings, the procedural status does not correspond to the function of the full-fledged defense. Very frequently, the attorneys on duty, let's say, that take a passive position, do not bother themselves studying the case materials, and they do not really prepare for the proceedings. The issue of the use of the adversariality in Kazakhstan is overdue, and we've studied in details the experience of the countries with effective adversarial proceedings. We were interested in the experience of Estonia, where the adversarial proceedings have been operating for more than 16 years, and the peculiarity of this process is the preparation and submission of the defense in the court of the Defense Act and the prosecutors the statement of the accusation. By visiting in 2018 Estonia, we were able to see how the adversarial proceedings go on. We got acquainted with the conduct of cross-interrogation. Moreover, we took part in the hearing of the appellate court where the criminal case was considered, and we looked at the defense and prosecution acts. Moreover, our colleague Pavel Goncharov provided us with the opportunity to get the draft prosecution and defense acts. It's noteworthy that under Estonian law, one and same prosecutor conducts the case from the moment of the beginning of the trial and up to the appeal of the verdict to higher instances. And by doing so, we see an increasing role of the prosecutor in the process. Moreover, we attended the adversarial process where, with regards to the Kemerov group, where 14 convicts were with 14 convicts and 14 attorneys. So, speaking of the speaking of indictment and how the indictment affects the bias of the judge, well, we've listened to the prosecutor who made an introductory speech, and in his introductory speech he did not refer to specific evidences. He only relied on specific or key materials of the case that were sent to the court as part of the indictment, and he asked the judge to study thoroughly the case materials during the court hearing. And only when the defense party provided its introductory speech, only then the court started to examine the case materials, which means that the prosecutor in its indictment does not evaluate the evidences. He only refers to the case materials collected by the police. It should be noted here that the zones of responsibility and the authorities of the police and prosecutors are clearly divided. The police is in charge of collection of materials, whereas the prosecutor is in charge of providing legal assessment of all of these materials. And he is in charge of taking procedural decisions on the case. He draws up and sends an indictment to the court, and the court needs to evaluate the evidence and decide on the case. It should be noted that back in 2017, the Chief Justice of the Republic of Kazakhstan, Jakub Kazhmanovich, while he was holding the position of the Prosecutor General, raised questions about the expediency of delimiting the powers of the prosecutor's office, pre-trial investigation bodies, and the court in the criminal proceeding. It was proposed to transform the activities of the criminal prosecution bodies, which were supposed to focus only on the identifying of the circumstances of a criminal offense under the leadership of the prosecutor's office. And the prosecutor must supervise the investigation, the pre-trial investigation, by making key procedural decisions and drawing up and sending an indictment to the court without the case materials. Back in 2017, this question was already raised. The court, in turn, must evaluate the evidence and decide the case on the merits. However, this proposal was not supported by the law enforcement agencies or the prosecutor's office. However, in many European countries, there is this model of criminal procedure that is carried out according to the police prosecutor court scheme, with a clear division of functions of each of them. I would like to say that the main judicial proceeding, well, we cannot really duplicate, the court cannot duplicate the work of the pre-trial investigation bodies and prosecutor's office, because the main litigation means the competencies of the courts to study the evidences with the involvement of the parties. That is why all of the novelties that we are offering right now are aimed at enhancing the human rights safeguards in order to improve our criminal proceedings, and we want to exclude the double assessment of evidence at the pretrial stage and in court, because at the pretrial stage these evidences are subject to evaluation as well as while they are in court. Therefore, we want to go away from this.
What is the advantage of the adversarial proceeding? The court does not have the opportunity to familiarize itself with the materials of the case before the start of the trial, which means that it does not have a formed pre-biased position. Criminal cases formed in the course of the procedure by the presentation of the evidence by the prosecution and the evidence of the defense by the attorney. The adversarial principle is implemented, and the responsibility of the parties for the preparation of the trial and the outcome is increased. Drawing up an act of defense, carefully preparation of defense attorney for the criminal procedure ensures a full-fledged qualified defense. One and the same prosecutor participate in the process from the moment of the start of pre-trial proceedings up to the final stages. It is an increased responsibility of the co-prosecutor's office and less complaints. The judge plays the role of an arbitrator between the defense and the prosecution. Therefore, as of today, the possibility of the adversarial proceeding is possible in Kazakhstan. Taking into account Estonian experience today, we prepare different proposals, which Mr. Jakub mentioned and Mr. Marat mentioned about the adversarial proceeding by sending the defense action together with the prosecutor's action with the indictment. I am actually meaning indictment without case materials. Increasing the responsibility of the attorneys, because evidence should be evaluated by the court for the first time. The elimination of the functions between pre-trial bodies, prosecutions of prosecutor's office and court. In the address of the president, it was mentioned that court is independent from the accusatory body. We want to ensure equality of the attorney and prosecutor. We understand that for implementation of this form of the judicial system, time is required. Therefore, we do not offer to move with the adversarial proceedings at once. Let's start with the with the medium and severe cases, where it is possible, where there is more room, then we can go to the grave and especially grave cases. And as previous speaker mentioned, that we should not make the attorney to prepare the defense action and to provide evidence. We agree with you in some areas. We do not exclude the possibility that the defense action or defense act will not be an obligation of attorney, but a right of attorney, where it is required, where it's needed, where it is, where the attorney wants to, he can provide this defense action. We would like to seek the support from all the authorities, from all the bodies, from prosecutor's office, from attorneys association. We want to increase the level of trust from our citizens and from public. Thank you very much, Gulnara. I think that after 4 presentations, 4 speeches, apologies, I have a small comment. Just one moment. Dear colleagues, it was a great pleasure to attend to your speeches, just to share my vision of the problem we are currently discussing. Adversariality, a character of the model, has a more conceptual nature, conceptual of justice in terms of the materiality and procedural thing. In terms of the materiality, it was a case in all the ex-Soviet countries when judges were thinking that they are continuation of the law enforcement bodies. As it was about the material material justice, because justice can be perceived by different courts differently, and we are not a punishing arm. It's more proper to say that it is justice in terms of the procedural nature, what we are discussing today, and what represent different models of adversariality, when the judge is not about punishing the defendant, but making a just decision, making the resolution, ensuring guarantees which will protect people who are not to be blamed. And it is very important to have this orientation of the whole law enforcement and the judicial system to the procedural system of justice. And here I think it's very good approach of the Supreme Court of the Republic of Kazakhstan about step-by-step incremental implementation of this adversariality proceeding, because we understand even if we move to the English law model, but still to preserve the material understanding of justice, nothing will change. It is not only about reforming of legislation, it is a complex work on changing the perception of the whole society about reorientation and preparation of the public, about mentality of the legal community, to the adversarial proceeding. And I hope that the tools and means from the Council of Europe, including the help program, will be very supportive in this process. Thank you very much. Can you please introduce yourself, dear colleagues, just to know who you are? And meantime, dear colleagues, I have a lot of questions to our distinguished speakers. And but since we are out of time, I have to give the floor to other colleagues. I think that we can discuss that directly with the speakers later. Or Sergey, I give the floor back to you. Sorry for taking more time than we were supposed to. And if there is no break, then the next session will be moderated by Mr. Georgi. You know him very well, professor and Minister of Justice from Georgia, and very respected expert of Venice Convention. Thank you very much, Aslan. I am really glad that after a pandemic, after a year and a half of a long break, now we have a possibility to come and see you in person, to see people, and to be here. We are 30 minutes late. I don't want to take time out of the administrative justice, and I hope that the Supreme Court will continue discussing adversariality in the future. And in Kazakhstan, we also had a lot of meetings, and also in other places we had such discussions. And it's great that the Chief Justice is still lobbying this issue, and I think that we will have interesting discussions in the future as well, with the support of international organizations. As for this session, I think it is very important topic. It is administrative justice, and you know that the last year there was a new administrative procedural code of the Republic of Kazakhstan, which was made effective in July. And I think that I'm really eager to hear more about that from colleagues from Kazakhstan. It's a revolutionary document. I think everything will depend on its implementation. I have a conflict of interest. I also have my speech, therefore I will not elaborate more on that. I will wait for my time. And now we have online speech. Unfortunately, not offline this time. We are a little bit late, unfortunately, and Ms. Habrieva is waiting for her turn for a very long time. She is a member of the Venice Commission and director of the Institute of Legislation and Comparative Justice under the government of the Russian Federation. Deputy chairperson of the Russian Academy of Sciences. She also participated in the developing of the draft code, actually. Ms. Talia, please, the floor is yours. Colleagues, good afternoon. It's a great pleasure to see all of you in a good health, and I would definitely prefer to be there with you, not online but offline. I see very familiar faces, and we have another big event going on in Russia, but I I left them and came here, and I was criticized that I am a very frequent speaker in Kazakhstan rather than other places, but I am ready to continue this tradition. I believe that Kazakhstan, among all the neighboring states, is the most advanced one, and also with a higher quality speed. I probably can tell you about the process itself, but it's probably more interesting to tell you about our findings and what has been interesting not only for Kazakhstan, because the code is already effective, but also for the countries of Eurasian region, definitely, and probably broader, even broader than that. The legal reform in Kazakhstan is for a long time in the focus of the Venice Commission, including the administrative justice, and such a high-level cooperation is acceptance by the Venice Commission of 9 resolutions for the Republic of Kazakhstan. And as for the administrative and procedural legislation, it's a very rare thing in our activity. Time of consideration from 2014 till 2020, there was legislation from Bulgaria, Albania, Georgia, and other countries. In 2014, in addition to Kazakhstan, we considered administrative procedures and from Georgia, and in addition to that, there was a separate consideration without resolution of the judicial reform in Kyrgyzstan. Therefore, administrative procedural code of the country was evaluated by the Commission for the first time, and this experience is very significant. Venice Commission made 2 resolutions connected with the administrative reform. First, finding about the administrative reform overall, and the second in more details about the administrative justice. The draft of the administrative procedural code, which is already effective, it has no analogs in the common law and in the legal tradition of the Republic of Kazakhstan, and it actually was of higher interest and even brought a discussion in Venice Commission. It is not very often that we have such discussions. Doctrine, including European doctrine, is in continued discussions. It is about comprehensive sectors, but comprehensive and complex does not that it's a mixture of administrative and procedural. And some experts in administrative justice object to the possibility of such codes due to the principal differences between proceedings of the executive bodies, which have the administrative functions of different governance aspects. And these are 2 different specific areas. If we look at the common law classics, administrative procedural legislation and has very serious specific aspects. Therefore, when the code was provided to the Commission and submitted to the Commission, it has very broad subject of regulation, and it is much broader than similar regulations, and actually broader than it was in the previous code in 2010 to 2020. The code regulated relations for public relations due to the administrative procedure, and also administrative procedural norms in the administrative judicial aspects. And even though before this code was made effective in Kazakhstan, there was a legislation about administrative offense. These facts, they pre-identified the particular complexity for evaluation of new document, and it was not just unique and original, it was also challenging in terms of the technological and legal aspects. I would like to draw upon some aspects because they are very important, and they will be playing an important role in the future. Commission had to look at the broader regulation with a different legal nature, and also about the procedure and proceedings. Innovation of the Republic of Kazakhstan is that in the legal system of the country there was first attempt to overcome systematization and the Soviet tradition, and many experts believe that it does not actually meet the requirements of the practice. As alternative, it was a functional and systematization of the legislation. It's not only about choosing new approach, but it's also about testing new sample, new model of systematization, while science researchers and scientists are still arguing. This is a legal artifact by Kazakh colleagues, and in addition to everything else, it is only conversion of the legal system. It is not the first experience for Kazakhstan. We can actually remember AFC, Astana International Financial Center. This is another example of unique nature, and probably this might be a trend in 2021. Another thing is this artifact can be an innovation in the development of the judicial system and legal system, because it's a new way of a new legal field for functioning of different different functions of the government, judicial and executive bodies. This case brought such an important area in the Venice Commission, which is not directly in our mandate and charter, but it was within the goals and mission of our organization. It's very important probably to hear to researchers and scientists such a thought that it's probably about creating and establishing, probably, again, discussions are possible, creating precedents of innovations in the legal and judicial systems, or the innovative approaches. By acknowledging this experience, this will be a path for other countries and systems. And it's not only about the fact of approving and acknowledging this practice of creating such a single code, but also innovation and argumentation of the Commission itself. Overall, we will still argue about that, and scientific academia will probably also argue, as a Venice Commission, as a research forum, also can actually make such hypotheses, and in particular that such hypotheses can be tested and practiced by of this body and organizations which will be functioning on the basis of this code and also on the basis of the practice of the Venice Commission to object or to approve the established practice. And I would like to remind that the Venice Commission and overall on the code on additional findings has some evolution. I don't mean the statements by separate members of the Venice Commission to actually actually objecting to this attempt to combine uncombinable. Initially, Venice Commission was drawing towards the decision that it is about different two codes for Kazakhstan. Comprehensively, they would be representing this area. But as it was indicated earlier, this is in the concept of the legal form of Kazakhstan. But in our final position, this was made that this document has sets clear rules in both areas of regulation, and it is functioning well. Different recommendations was about the code and about the administrative procedure, and in terms of the general principles of procedural part, and participation of the parties' administrative proceeding, and suspension of the acts in the court. Such a comprehensive document, difficult document, had to be finalized in different principal positions I would like to remind that the Venice Commission welcomed some key principles to be included into the code. This is the justified timelines, legality, and other aspects, and also individual rights spectrum, which had to be regulated by the code. It was suggested to include as a personal right to submit complaints for the interest parties to appeal against the acts, and also efficient administrative procedure. Traditional subject of the Commission, even though it was quite vague, and the prosecutor's office has a very strong procedural position in the judicial system, but after the conference of the Council of Europe,
And this event was held not long ago in September in St. Petersburg, so probably this critique would be voiced because we received the answers which were quite satisfactory for the representatives of the Venice Commission. I think that it is also really important to pay attention to the recommendation on the administrative regarding the administrative discretion, and I think that these issues will be the subject of the discussions to an extent that it is possible as part of this very brief session, but I think that the partners will share information about how they approached these problems. I can just say that I was impressed by the fact that this code is a living law, and that's one of the foundational legal documents, and that it takes its own development path. And in September of last year, the Prime Minister of Kazakhstan approved the extensive list of laws and regulations that need to be adopted to implement the in order to implement the APPC. So overall, I can say that the Commission provided high assessment of the reforms and noted that the reforms are very well versed and they bridge in some gaps in the legislation and introduce new procedural mechanisms, thus making a positive contribution to the administrative justice. And I would like to remind you once again that in a timely manner, the Venice Commission mentioned the excellent cooperation with the Kazakh authorities in terms of preparation and conduct of legal reforms. And I can state with confidence that such an assessment will remain fair even in terms of future cooperation with the Venice Commission and the Republic of Kazakhstan. Thank you so much for your attention. Thank you very much. We could hear you very well, and sometimes well, we have some technical issues. I suggest that we make smaller changes. We'd like to listen to the opinion of the chairperson of the new administrative board under the Supreme Court, Mr. Kanat Musin, if he's okay with that. Could you please share your opinion on the work of the administrative justice in Kazakhstan? Thank you. By the way, I would like to welcome other colleagues. I didn't really know that these were your colleagues because I haven't met them in person yet. So I welcome all of the colleagues, newly appointed colleagues as well. Thank you so much. Thank you, dear Georgi. Indeed, today at our forum, we have the judges of the administrative board under the Supreme Court. This is the new institute and we are very happy to see that today we have an opportunity to tell you about those results which we were able to get after the enforcement of the code. You all know that starting from July 1st, the system of administrative justice started its work, and in fact, a lot of developed countries think that this is kind of obvious, but we were trying to reach these reforms for 30 years. On one hand, this is a very long period of time, but on the other hand, we had an opportunity to learn that experience that was present in separate CIS countries, and we had an excellent opportunity to avoid some mistakes which were made by other countries when they were developing their own codes. Taking advantage of this opportunity, I would like to thank the Venice Commission for a significant contribution to the development of our code and for your assessments that you have shared with us. And we assume that our cooperation in this field will keep going on. Next slide, please. We have chosen the German model, and we've created the symbiosis of the material and procedural norms, and we created the full institutional base. We've created 21 courts in the regions of our country, 21 specialized inter-district administrative courts, and 17 respective boards on administrative cases under the regional courts, as well as the administrative board under the Supreme Court. We see that being a judge, especially an judge of the administrative court, is prestigious all over the world. And you can see the quote by Roy Kahn, "Don't show me the code, show me the judge." During the transition period of 1 year after the code, between the adoption of the code and its enforcement, we've trained more than 350 judges. Then we had a scrupulous recruitment of judges to new courts. The judges of the administrative courts are imposed a huge responsibility, and the population has expectations from these courts. That is why we took all necessary measures in order to make sure that our courts are equipped with qualified personnel. And the main difference is that unlike the civil procedural code, the APPC has a totally different paradigm with regards to the subjects that are being protected by the courts and with regards to the role of the court in this process. The Supreme Court needs to note that for the first time, the judges were selected out of the group of renowned lawyers with a lot of experience, including the international experience, because those were the experts that had legal or tax background as well as antitrust legislation that overall allowed to update or refresh the work with the human centricity in it. As regards the first results of the work of the administrative courts during the first quarter or 3 months, during the 3-month period, as you see, more than 7,000 claims were filed. And of course, this is not a big number on the scale of the country. However, we see the annual markup up to 30%. Monthly markup, sorry, up to 30%. And well, this is just the beginning of the process. And we see that this code is just being recognized, let's say, or tested by the population itself. Overall, we project or we forecast that starting from next year, there will be a serious increase in the caseload and increase in the number of claims. The greater number of complaints are the complaints with regards to the work of the bailiffs. Then come state procurement, land issues, and tax issues, and so-called other or contingent issues related to healthcare, provision of state services, audits, agro-industrial issues, and so on and so forth. In total, that results in 83% of all the cases of other categories that I have not listed yet. The peculiarity is the possibility to reconcile with the administrative bodies, and we see that reconciliation is generally accepted by the population, because 354 reconciliations were reached between the administrative bodies and the citizens. In addition to that, About 1,000 claims have been withdrawn before the start of the criminal proceeding because the parties were able to reconcile prior to the trial. A lot of reconciliations were reached with the help of a judge. And we see that just a regular address to the court already instigates the administrative body to reconcile with the claimant for him or her to withdraw his or her claim. And that's quite common. What's the reason for withdrawal of a claim? That's the cancellation of an indictment by the administrative body or reconciliation of the parties, as well as exhaustion of a dispute when the administrative body accepts its guilt or recognizes its guilt and restores the rights of the citizens in other way. And at the same time, a significant role is played by the court when it exercises its right to express its legal position, as a result of which the prospects or the focus on the result becomes more evident. Next slide, please. Of course, the first decisions have already been made. There are 1,344 of them as of October 1st of 2021. You see that in favor of the plaintiffs, 43% of decisions were made. 57% of decisions were made in favor of the administrative body, and in our opinion, this is a huge breakthrough because prior to the enforcement of the APPC, the percentage of satisfied claims in favor of a plaintiff were no more than 15%, and here we see the threefold increase in the number of decisions in favor of plaintiffs. And if we take into account the fact that there are some other examples of reconciliation or revocation of claims or withdrawal of claims, then this percentage, of course, may be even higher. I would like to mention separately this new instrument that is called monetary charge or pecuniary punishment that we have not used in our courts earlier. As you see, within the 3-month period, such a type of punishment as pecuniary punishment was used in 114 cases, and among them 35 officials were imposed a pecuniary punishment, including the head of the Committee for Construction and Housing and Utilities of the Ministry of Industry, and 48 pecuniary punishments were imposed on the members or staff members of the mayor's offices, including the 3 heads of the local authorities. You see that the level here is quite serious. Because previously they weren't even affected by the courts, as such a norm did not exist earlier. And I must say that this measure significantly affects the discipline of the administrative bodies, and right now they're more disciplined at courts. Earlier, the representatives of the government bodies would not even appear at court hearings until the APPC was integrated and enforced, and they would even win the cases without being present at court hearings, whereas right now this practice of ignoring the court hearings is impossible, and we observe a totally different approach on the part of the administrative bodies. And we should admit the fact that this has been perceived by the society quite positively, and as a result of the 3 months, about more than 4 million tenge of pecuniary punishment was imposed on the administrative bodies. And the peculiarity of this norm is that it must be implemented, and very rarely it is appealed. So about 4 million tenge was already paid to the budget, and this norm seems to be very efficient. Of course, next slide. We have the so-called return of a claim by court, but we do not consider it as a problem. We think that it's mostly considered as accumulation of experience. We sometimes have greater expectations from the administrative courts, thinking that they can consider any type of issue. That is why the main issues include lack of jurisdiction or so-called non-jurisdiction, as well as non-compliance of the pre-trial order of dispute resolution. All of these issues are being thoroughly analyzed by the Supreme Court and by local courts, and we carry out an active outreach campaign. We opened our accounts of administrative justice in the most popular social media, where we publish both explanatory material as well as real material from real cases and real court decisions on certain claims. We also carry out live interactions with the judges on the application of the APPC, and in our opinion, all of these things actually help the population to better perceive their new administrative justice. I am sure that in the future, the mission of the administrative justice in terms of the protection of the rights of people and businesses will be developed and supported even more. So, the first results of the first 3 months of work inspire us and encourage us to think that the model of this APPC is quite fortunate or successful. Here you see the mentioned how the APPCs were mentioned or let's say discussed in the regions. It's 2,253. I think that APPC will be even more supported by the population, and the code itself is very well versed, well, undoubtedly, just like any new model, we have the period of some instabilities. We are now accumulating all of the issues that we deal with in terms of the application of the code. But nevertheless, I must say that we didn't have any drastic omissions or gaps that would prevent the implementation of administrative justice, and that's was possible thanks to the developers of the APPC, including the Venice Commission. So this is what I wanted to tell you, distinguished participants. My report is over. Thank you for your attention. Thank you very much, Mr. Musin. And thank you for sharing really good examples and sticking with the time limit. Thank you for giving an opportunity to our colleagues to keep working. Let's move on according to our agenda, because we have another third session upcoming. I would like to give the floor to Roman Podobrigora, director of the Caspian Public Law Institute of the Caspian University. We had a chance to work with him under another important and very well-known project. Roman is a renowned expert from the academic circles who actively participates in different events. Roman, the floor is yours. Thank you very much, Georgi. Good day, or good evening, dear participants. My speech is a logical continuation of the speech of Kanat Sergeyevich, but let's say I'm on the other side. And probably it would be quite interesting for you to listen to the opinion of a person from the non-judicial sphere. Indeed, people were waiting for this code for a long time, and now this code is being tested by lawyers, judges, and regular citizens. And over the last 4 months, the responses were diverse. They started from this euphoric attitude that everything is great, and they were finished by some disappointments that nothing has changed. And the numbers that you have demonstrated today in the two presentations by the Chief Justice and the Chairperson of the Administrative Board, we see that the situation is changing, but one needs to be careful about numbers because if we look at the statistics of the private bailiffs, the picture will change, I think. But in addition to numbers or figures, we see a lot of interesting cases and opinions of the lawyers, attorneys, legal professionals, legal consultants, and I carry out trainings for different target audiences, and I always ask my target audience about what are their impressions and what are their opinions. And the dominated opinion as of today is that the situation changed. I think that the situation with the APPC is a good example of the legal psychology because thanks to the serious outreach work, the population heard about the appearance of new courts that are more fair or more just. And well, sometimes the legal entities or natural persons try to enter administrative courts because they think that they will find truth there. Certain things changed in the mindset of the judges, and I don't know what actually affected that, whether this was an enlightenment work of the Supreme Court or the shift of the workplace or the tool set that is being offered by the new code.
But they became braver, more courageous. But in terms of quality and quantity, for the existing judges, 150 judges came into the system. I was a bit pessimistic and I was very cautious about the code. But what is happening now makes me very hopeful and enthusiastic. But still, we need to acknowledge that there are some challenges and problems. This is not a just simple regulation in terms of definitions, in terms of coordination with other regulations and legal technique. Before making it effective, there were already 2 amendments, and actually there are expected more. What comes into attention and what conclusions can be drawn in terms of some problems for the past months? There is misunderstanding of new tools in governance. First of all, it is about differences between administrative acts and administrative actions. So we used to act as something formalized. The document and the action is actually some deed which using physical power, for example, or closing down a premise. But in the code, it is a little bit different. It's especially on the direct impact, effect on the rights and freedoms and use of physical power. This is act, but for example, at pedestrian crossing, this is a deed or activity. And the difference can be still felt by not too many people or is not actually seen by many, both for plaintiffs and attorneys and judges. Sometimes when Akimat is refusing to provide the land, it is not action but act, or legal authorities about the legal act. And it is the requirement is to go to more superior bodies to provide to ensure the right to the land plot. It's also Norm 29, which still has a previous understanding of such public administration, both for acts and deeds. Dispute resolution, and this was a problem. We can now make a deal and settle the dispute with the government. It is this disciplinary action, and figures are already showing. But again, such procedures are applied where they can be, and sometimes where they shouldn't be. it is actually forgotten that the reconcilement or the mediation is possible not at all sides. And as Ms. Habrieva mentioned, there is some misunderstanding. One of the cases, plaintiff makes a decision to reconcile with the police, which illegally actually took his car. It is not not possible to reconcile because it was a legal activity. Taking into account that the public administration is a complex structure, very often it is very difficult to identify who is superior to who. In some regions of Kazakhstan, for example, it is considered that the local authorities, as departments of health or departments of education, they don't have the superior bodies, or Akimat is considered to be a superior body. Another common problem about appealing against the acts of the government authorities, because if it's a legal power or power of legal entity or not for public administration, it's not of such a high importance. Another problem connected with the problem on whose acts and deeds can be appealed in the administrative courts. Legal consultants and attorneys complain that the civil courts sent to the administrative court against the against the associations and the condominiums that it was before, against the deeds and acts of the public administration, and it was different before, and even now it is totally different. In one training seminar for judges, I've seen such a topic about appealing against associations and organizations. Public organizations. This is very obsolete title, as we need to actually be very very cautious with the confidentiality and non-jurisdiction. It was relevant for other legislation, for other legal institutes. Dispute, for example, where issues should be considered with the responsibility and liability of civil servants, and it is very complicated issue. But to make an example of regulations and norms from the time when all the people were working to the government is not actually applicable. Taking into account the time limit, I am not including some of the positions, but one moment which is linked to very important things about the regulations which ignore the administrative procedural code. As an example, recent amendments to the law on prosecution and prosecutor's office, where the prosecutors have a right to cancel administrative acts. We have to understand if we are working on administrative justice or we are still working on procedural supervision. These two institutions cannot go hand in hand. It should be, we should complement Supreme Court and other courts, not because we have a Supreme Court as the organizer of this event, but it is very serious outreach and serious educational agenda, now less systematically, but still there is a lot of information and outreach programs. As far as and public administration, the first part of the administrative procedural code, it is just a guesswork whether government authorities are already applying the norms of the administrative procedural code, but with some indirect evidence. Some principles are already in operation, others are not so much, and we should pay compliments to the courts which are taking that into account. And such event as one held today are needed to evaluate and assess the administrative code in relation to the procedures and procedural part. Just to make an example, in one of the trainings, as a joke or seriously, I was asked whether I can tell where this campaign will be continued from the government. So people believe in new code, but they have some concerns whether this will be for a long time. I hope that approaches with the administrative procedural code, especially with administrative justice, will be staying for long and better forever. Thank you very much for your attention. That's all I had. Thank you very much, Roman. It's very interesting always to have an external perception and external opinion. It helps always to be even more active and to tackle the problems. Now it's my turn, and my other speakers simplified my job, actually, because a lot has been already said, and even though it can be said a lot about administrative justice, which start functioning just now, and it's not enough to have one session, and I know that Sergei is already having some additional ideas to move again to discuss these topics, and that Supreme Court is actually ready to continue our meetings and discussions, our roundtables, and to discuss the new code. I will speak about Kazakhstan in short and about Georgian experience. We've already spoken about Kazakhstan with the new administrative procedural code. We have new Institute of Administrative Justice in the country, and the code settles some guarantees which ensure civilians' participation in fixing the protection mechanism of the rights with the government authorities or in the court. There are steps taken with administrative justice, and it ensures transparency of the activity of the public authorities in ensuring rights of the citizens and to combat corruption in this regard. As you probably know, the code in Georgia, we had it in 1999. It was a separate administrative code, and later as administrative procedural code. And it's very interesting to see how they are working in both countries, because we have a lot in common. Just 2 words to add about Kazakhstan. As you probably know, the code was, the process of developing this code took almost 10 years, and it shows how serious intention was, and the result can be seen already in the code. There were a lot of ideas on that path, which brought different legal documents. It was based on 2 different legal acts about administrative procedures and administrative procedural code. In 2016, there was a separate law. We will not waste time on that. In 2018, it was a presentation of the administrative procedural code, which had absolutely new approach in developing legislation and the legal tradition of Kazakhstan, and the code unified regulation of administrative procedures and administrative judicial system in public relations, and therefore expanding the subject of regulation. As Ms. Khablaeva already mentioned, the Venice Commission provided its resolution. I am really glad that my colleagues had an opportunity to participate in developing a position of the Venice Commission. A novelty and innovation of this code is during the administrative act acceptance. Civilians have a possibility to be heard and to appeal against this act before going to court, and this is a possibility to reconcile this dispute at the government level without going to trial. The model of administrative procedure assumed creation of special administrative courts, and colleague before me already mentioned about steps made towards achieving this goal, creating 21 courts, and additionally more. on a regular basis due to the civil services and different permits and appealing against these permits. It is a liaison of the civilians with the government authorities will not be so bureaucratic and red tape. And as I know, there were already first steps when the courts are very brave in making the decisions, and I hope it will be continued in future. And if not, Mr. Rahman and others will offer their criticism in our next meetings, and we will continue discussing this topic. It should be mentioned that the development when the Venice Commission was working on that, the Ministry of Justice and Supreme Court, they were very active working on the project. And I should mention that in the Ministry of Justice and Supreme Court were actively participating in debates and discussions. Mr. Tukiyev was very actively working with us, and he was visiting Venice Commission, and now he is the judge. He's not just theoretically as author, but in practice he can apply ideas he had in the Supreme Court during the development of the specific parts and provisions of the code. It should be mentioned that the Ministry of Justice had a project with the World Bank on further development of the institutions of administrative justice and administrative procedures for the roadmap and implementation till 2025. In this project, there were experts involved from Germany, Georgia, Poland, Latvia, and Rahman, Mr. Podelka, and Almat Gabasov also is present here. He took an active part from Latvia, the Supreme Court members, and the chairperson of the administrative colleague. And it was a great pleasure to work with them for 2 years and while coordinating their activities. It's very important when the concept was implemented, and the resolution on the concept was done by Bureau on OCT on the Commission on Human Rights, which positively assessed its implementation plan and provided additional recommendations, which will be taken into account by the Ministry of Justice and Supreme Court. We already mentioned about the statistics, and it's very important that in future it would be studied in more details how it is operating and functioning. We have very hopeful figures, not quite significant figures for the beginning, and in the future dynamics in 1 or 2 years, it will be interesting to observe the dynamics. As for Georgia, as I mentioned earlier, in 1999 we had the administrative code, the general one, made effective, and a year after Administrative Procedural Code. In Georgia, Administrative Procedural Law went through several reforms. The first wave was with the independence phase, and such important fact, that as a membership in the Council of Europe, and we had our commitments in terms of harmonizing our legislation with international legislation, which assumed for different legislation and bylaws to bring them in line with the standards and norms of the Council of Europe. To understand that in EU, and also to protect parties from administrative burden, and to have to make effective the legal relations between them. The General Administrative Code, for the first time, defined administrative body and the functions of administrative body, also the procedure of making decisions by administrative bodies in public relations, involvement of parties in this process and stakeholders, and public liability. With the procedural code, it was administrative justice, and the code, identified code, established of the judicial nature and appealing against the administrative courts. In the system of general courts, complaints are considered in administrative field. If it is about administrative legislation, procedural measure on protecting rights includes resolving settlements and in the first instance courts, also to appeal and cassation instances. In line with the Georgian procedural legislation during the administrative justice, we also have the administrative procedural code only in the norms if this issue is not regulated otherwise. If both codes regulate this issue, administrative procedural code will prevail. Important principle is the active role of the court, and as you probably know, whether eligibility of the court based on the public interest, on his own interest, has to take care of the evidence collection required for the administrative dispute. Important instrument, important tool to identify real guarantees of the rights protection of the party in the Georgian legislation is also norm in the legislation which is about a suspension of the appealed verdict before the resolution. In line with this norm, administrative act is suspended before the resolution is made. Suspension effect of administrative complaints. This is a nutshell. I even cut my presentation to respect our next session. This is for Kazakhstan. This new code is very important step for administrative justice development in this new sphere, new institute. Therefore, it's very important to ensure its proper implementation, because we know that in some neighboring countries, even earlier such codes were accepted, but the criticism towards implementation, the results are not observed by citizens of these states, nor government authorities, no public associations. As friends and supporters of this process, when we meet in a year, in 2 years, in 5 years, we will not speak as about our other countries, but Kazakhstan in the region will be an exclusion, which is actually implementing a full-fledged code. And it's very important in terms of this, there is a political will, because the code was made effective. It was made effective in 2020, but it was actually put in practice in 2021. It means a serious preparation of judges to streamline the implementation and to make the code more efficient in terms of performance. This process should continue. There are a lot of events and activities to be held to use this opportunity, some key events, and improving the legislation and the administrative procedures, bringing in line some sectoral legislation, internal instructions, practical guidelines, special courses, training for legal consultants, courts and administrative bodies to improve cooperation between government authorities and so on. Thank you very much. And I think we are on time, but if there are just brief questions, please go ahead.
Are there any questions? Or let's postpone these questions for future seminars and conferences that Sergei and other friends of ours will organize, as well as the Supreme Court. If you don't mind, I asked Roman Anatolyevich, and probably I said it to you. I would like to make a comment with regards to the figures that cannot share it on the screen. There was this figure 47. Roman Anatolyevich, if we remove the private bailiffs, and that's what we actually have done because we were interested in it. The numbers are even better. Then the number increases by 2%, and it's 49 instead of 47. If you look at the Akimats, then the number will be above 50. There will be about 53%. Okay, we can provide these numbers. We have conducted this analysis. Thank you. Are there any comments or questions? We have 2 more minutes. Okay, then as far as I understand, the Administrative Justice is more active in the morning or until 6 p.m. Of course, I'm joking. Administrative Justice is always active. It works 24/7. Then now I suggest that we move on with our third session. I would like to give the floor to Mr. Tigran Karapetyan, the head of the Division of Transversal Challenges and Multilateral Projects of the Council of Europe. So you better say how your department is named. So this session is devoted to a very interesting topic of the effectiveness of judiciary, new technologies in facilitating CPESH standards. Thank you very much, Mr. Papashvili. Thank you so much for catching up with us. And since we were quite late and behind our schedule, I think that, well, right now we are almost in line with our agenda. In this session, we are going to talk about the effectiveness of the judiciary and new technologies, and we'll talk about those standards or challenges that we have to deal with. These are the challenges that we need to deal with during the reforms in the judiciary, and at present we try to apply IT technologies and new technologies commonly, unless these are the technologies that intervene with the processes. We use the communication technologies using IT methods, and that's what we're going to talk about at this session. So, without disclosing the point of this session, I think that experts will do it better than me. I would like to give the floor for introductory remarks the president of the CPESH, Mr. Ramin Garagurbanli. Mr. Garagurbanli, as far as I know, you're online. The floor goes to you. Thank you. Can you hear me? Yes, we can, but we cannot really see you. Oh, here you are. Is it okay now? Yes, yes. Excellent. Excellent.
Yeah, colleagues, the distinguished colleagues, I will make my speech in English. I would like to begin by expressing my appreciation to the organizers, Supreme Court of Kazakhstan, Council of Europe, and European Union delegation for having invited the European Commission for Efficiency of Justice, CPESH, to this international roundtable on the reforms of the judiciary in Kazakhstan, addressing new challenges by using best international practices. I regret, of course, not being able to participate in this important event in person. However, we have to adjust to new realities and use the tools we have at hand. I would like to extend my gratitude and that of CPESH for being given the opportunity to take part remotely and contribute to the session on efficiency of justice, new technologies to support the promotion of CPESH standards. When discussing reforms of the judiciary, it's important, of course, to reflect on how they are a stepping stone towards making justice accessible to all by improving its efficiency and functioning. Almost 20 years ago, by creating the CPESH in 2002, the Council of Europe, decided to prioritize working more closely on efficiency and quality of justice at a national level in order to tackle the increasing number of cases at the European Court of Human Rights. It also demonstrates the will of this organization to promote the rule of law and fundamental rights in Europe in conformity with the European Convention of Human Rights. As you know, CEPESH has been entrusted by the Committee of Ministers to analyze various national judicial systems in their compliance with the requirements and standards of the Council of Europe, prepare and publish a biennial evaluation reports on judicial systems across Europe in order to have a precise picture of the situation, including detailed indicators such as budget, performance, and quality, situation of justice professionals and users. Also define good practices stemming from this report, identifying challenges and advice on areas for possible improvement in all 47 member states. Today, CEPESH is a unique body which consists of representatives of 47 member states of the Council of Europe and of 4 states which have been granted observers status in addition to Kazakhstan, namely Guatemala, Israel, Morocco, and Tunisia, as well as many international organizations of justice professionals. CEPESH experts within 4 working groups on quality of justice, evaluation of judicial systems, judicial time management, and cyber justice have developed methodologies and tools with a view to offering a framework and guarantees for an efficient functioning of judicial systems and for a justice of quality. As we do not have sufficient time to tackle all of them, I invite you to find out more on our website, including how CEPESH has also contributed in practical terms to achieving its goals through cooperation projects. Allow me to concentrate more on our activities related to the evaluation of judicial systems and adopted ICT and artificial intelligence standards, which are relevant for today's session. In order to fulfill its tasks, CEPESH has undertaken since 2004 a regular process of evaluating the European judicial systems every 2 years. And this process covers collection and analysis of judicial data submitted by the national correspondents. It's worth mentioning that national replies also contain descriptions of legal systems and explanation that contribute greatly to the understanding of the figures provided. I would like to stress out that this report is the unique source of information about the whole judicial systems across Europe, and this source of information is considered today not only useful for Europe, but also worldwide. Easily accessible to all citizens, policymakers, law practitioners, academicians, and researchers on CEPESH-STAT, a genuine database on the judicial systems of the Council of Europe's member states. They are therefore a useful complement to the report, which allows a better understanding of the functioning of justice in Europe. It also allows for the comparing of judicial systems and exchanging of knowledge on their functioning. And the scope of this comparison is broader than just efficiency in a narrow sense. It also emphasizes the quality and the effectiveness of justice. The last CEPESH evaluation report covering the period of 2018 and 2020 was published in October last year, and we welcome Kazakhstan's participation in this evaluation circle for the first time as observer state. Ms. Adia Ramazanova, as a national correspondent of CEPESH, will give a detailed presentation today. During the COVID-19 period, as you know, member states have made considerable efforts to adjust to new circumstances within a short period of time and to make the best use of existing resources to ensure the functioning of their courts and upkeep legal guarantees. In June 2020, the CEPESH adopted a very interesting document named Declaration on Lessons Learned and Challenges Faced by the Judiciaries during and after the COVID-19 pandemic. And several states contributed, providing comments on the management of the judiciary including Kazakhstan. This unforeseen situation, which we are all still facing, has demonstrated the need to rely on information and communication technologies tools. And we should keep in mind that the development of justice information systems should not call into question the basic principles that underpin judicial activities, respect of the fundamental principles of this trial, essential guarantees of our judicial system, such as the premise of the rule of law, the independence and impartiality of the judge, the principle of adversarial proceedings, or the protection of fundamental freedom. Stemming from the recommendation of the Committee of Ministers of the Council of Europe, establishing the European Commission for Efficiency of Justice in 2001, special attention should be given to design and redesign of court systems and legal information system in a cost-effective manner, and the delivery of court and other legal services to citizens through the use of information technology. CEPEJ is very actively engaged in wide reflection with its member states to support them in the modernization of their justice systems by developing tools with a view to offering a framework and safeguards to create and use ICT and artificial intelligence mechanisms. And these do not constitute an end in themselves, but a means available to policymakers, professionals, and parties to proceedings, further extending their effects for improving the efficiency and quality of justice through ICT. For that purpose, CEPEJ has developed and adopted several very important documents, and the most important one being the first European Ethical Charter on the use of artificial intelligence in judicial systems. This innovative text sets out 5 principles to guide the development of artificial intelligence tools in European judicial systems. The other documents, called Guidelines on how to drive change towards cyber justice, is also accompanied by a toolkit, and these have a dual objective. Firstly, they take stock of existing solutions at the European level, while at the same time considering their goals and ability to improve the quality and effectiveness of judicial system. And the second objective is to help policymakers master the change process towards cyber justice by putting the general principles into perspective, along with some feedback considered particularly useful in connection with the development and implementation of European digital justice policies. Last and not at least, the most recent and this is the guidelines on video conferences in courts. They provide a set of key measures that states and courts should follow to ensure that use of video conference in judicial proceedings does not undermine the right to a fair trial, right to access to justice, as enshrined in Article 6 of the European Convention on Human Rights, and meet the requirements of the Convention for the Protection of Individuals with regard to automatic processing of personal data. And the purpose is to provide states with a framework aiming at eliminating any risk of a violation of the parties' rights during remote hearings, in particular the right to be heard and to actively participate in proceedings and the right of defense. We will hear more about good practices of our esteemed colleagues from Slovenia. They will also share with us and with you with their experiences. And our colleagues from Slovenia, the Supreme Court was one of the winners of the Crystal Scales of Justice, and the experiences also the experiences from Kazakhstan will be presented today on the use of new technologies in justice reforms. Allow me to conclude by saying that reforms of justice system lead to fair, efficient, and accessible judicial system, and the use of new technologies should be promoted as they complement achieving that goal. CEPEJ is ready to provide you with the support you may need in this context, by putting at your disposal all relevant CPESH tools, as well as the expertise and experience of its members and specialists. And this would strengthen the fruitful cooperation already initiated with Kazakhstan. Dear colleagues, I would like to thank you once again for your attention and look forward to an interesting discussion. And I do hope that the alleviation of travel restrictions due to the COVID-19 will soon allow us to meet face-to-face in the future. Thank you.
Thank you very much, Mr. Gara Gurbanli. We are very sorry that you are not here today with us personally. Nevertheless, thank you so much for providing your online speech. I think that you have provided substantive information on what CPESH does and how the standards developed by CPESH help us in improving the effectiveness of justice in our countries. And I think that the experience that you mentioned and the experience of the colleagues from Slovenia will be commonly discussed here. That is why I would like to give the floor to Mr. Rado Brezovar, Secretary General of the Supreme Court of Slovenia, who is going to talk about the monitoring of effectiveness and quality of the judiciary with the use of CPESH instruments. Experience of Slovenia. Mr. Brezovar.
Thank you. Thank you very much for the introduction. Thank you to moderator. Thank you to organizer. Thank you to Ramin for the introduction. And I would like to express my gratitudes for the invitation to this roundtable. I would like to express my honor and the pleasure to give you the presentation of our Slovene experiences, and I really regret I cannot be in your country. I cannot discuss with you in live, but this is the fact, and we all have to face with this situation. I would like to share the screen. No. We see?
We see it.
Yeah, but I have to share. Is this, can you see my presentation?
Not anymore. We saw it in the beginning, though, when you shared it first.
It is not, does it work?
Not yet. If you could try maybe pressing on share screen again.
So I think it's obviously wrong with...
This is yet another, not the least reason why we regret not having you in here.
Yeah, it is. So I would like to ask organizer, just because I sent it also to you. I don't know what is going wrong. I've done it so many times.
Okay, we see it, Mr. Brezovar.
You see it?
We see the presentation, yes.
Okay, perfect. So next slide, please. Okay, I'm really sorry for this. Now we are sharing the screen from Nur Sultan. So just one fact: Slovenia can't compare with Kazakhstan on the number of population and the space. We are 10 times smaller in the figures of population, and 130 times smaller. Or Kazakhstan is bigger compared to Slovenia on square kilometers. But I think we can really share some of our experiences, some of our understandings, and we were, and I think we still are in the period of transition. So we have much more in common, I believe, than we think at the beginning. Next slide, please. I would like first, I think what is really important for Slovenia is that we have quite high level of the judicial self-independence. If we observe the governance of judicial system from 5 pillars, the budget, human resource management, administration, and ICT support are within the competence of the Supreme Court. So Supreme Court is responsible for defining the budget, sharing the budget, allocation of money to the courts, definition of posts for the courts, for the judges and judicial staff, for the judicial administration, and also for computerization. So in the Supreme Court, we have a special organizational unit which is competent for the development of information technology systems. So this really gives us a lot of independence and power also in the field of organization. The only field which is not covered is training. Training is performed by the Ministry of Justice. And the Supreme Court really plays the crucial role, as it was said at the beginning of this roundtable, in this field. And this is since 80s. And after independence, this was also regulated in the law on courts. Next slide, please. What is typical is that since early 90s, all key performance indicators were really very, very much implemented into our organization. And when CEPES was established, we immediately took all indicators which were defined in CEPES documents. There are 2 basic documents. One are guidelines on statistics, and the second is guidelines on judicial timeframes. And all these analytical information and indicators, all these quality indicators were immediately implemented into our systems. Next slide, please. I would like to share with you 5 different experiences we developed and we implemented into our systems and might be perhaps interesting also to you. First is our President's performance dashboards, then strategic work program, one event opening the judicial year, and some annual publications. And I would like to finish my presentation with IQ Justice. This is the project which received, as Judge Gara Gurbanli said, the Crystal Scales of Justice 2 years ago. Next slide, please. First are the President's dashboards. I put 2.0 because this is the second generation of dashboards. For the first generation of dashboards, we received a special mention in the Crystal Scales of Justice competition in 2012. We started to develop these dashboards in 2010. And these were first dashboards in Europe in the judicial sector. And these dashboards really covers all CEPES indicators and also some additional indicators and give presidents the insight of the functioning and of the performance of their courts. These dashboards also give the insight to the Chief Justice, the President of the Supreme Court, to the entire functioning of the system. They are composed on 5 components, and there are some sub-components. One component is focused on the human resource management and also on the workload and comparing the different ratios. The second is our timeframes. The third are key performance indicators based on the CPES standards. The fourth are hearings, and the fifth is the quality and the legal remedies. So these 5 components give the insight to the president, but beside of that, of course, there are several different reports in the system which offers the analytical staff much deeper insight in the functioning of the court. Next slide, please. The next practice is so-called 6-year strategic work program. This is a document which has to be delivered, has to be drafted by the candidate which apply to be a president of the court. Every candidate has to draft such program before applying for his candidacy. This is according to our law on courts. And in this strategic program, the candidate assess based on KPIs like disposition time, clearance rate, age of pending case, and so on, the situation in the court where he applies to be a president, and defines also some business goals, defines priorities, and also the tools for monitoring this. And the system which is behind and used behind this are president's dashboards and reports integrated in the business intelligence system. The next slide, please. We, every year in February, President of the Supreme Court, Chief Justice, organize the opening of judicial year. This is a public event for the professional and lay community, where the judiciary express the commitment to the constituency. And in this there is a document drafted for this event, and in this document, all indicators are analyzed in order to evaluate the performance for the previous year, and also to define priorities, measures, and also the tools for monitoring for the next year. So this is the event which is really open to the public. The president of the state, the prime minister would give their speeches, and of course the chief justice and the minister of justice would also give the speech and explain their views. The next slide, please. The fourth element are annual publications. Every president in our court has to draft every year the annual work program. This is according to the law, and until the February for the previous year, also the annual report on the performance of the court. Both documents, program and report, are drafted automatically from the business intelligence system. Of course, then the document can be edited, but it is important that all data are taken from the system. System gets this data from the case management systems. So this is automatically generated from case management systems, which are tools, of course, for monitoring the business process in the court. And these data are then transferred to the data warehouse and then enable generation of this information, which I explained later before. And the third document is the document of the President of the Supreme Court. And this is assessment of execution of judicial power. This document is sent to the Parliament. And I have just in 2 weeks, on 11th of November, the meeting of one of committees of the Parliament, where I will have to explain, together with the Chief Justice, this assessment of the execution of judicial power. This is a document of 150 pages, analyzing all indicators, which really gives the complete insight in the functioning of the entire judiciary. This document is sent also to the Judicial Council and the Ministry of Justice. Next slide, please. And finally, we are really proud on this IQ Justice, the project which was launched in 2015 and received the Crystal Scales of Justice in 2012, which 2019, and it really improved the quality of the entire system, not only of the adjudication, but also the quality of functioning of the court, improve the competence of judicial staff, also the satisfaction of among judges and also court users raised in these past years, and the increase of the trust in the judiciary really raised. We are not satisfied yet, but really we have now a tool to monitor and a tool which can also give us some other visions, I would say, in this regard. The next slide, please. I would like to finish with the words of our head of the unit, who really started with all these activities. It's not only about statistical data analysis, it is about the change of habits, work methods, and mentality of judges and other employees. I would like to say that there is a stress to change the attitude, to change the culture, which was also stressed in previous sessions. And also in the judicial administration, we recognize the same. And this cannot be, first, what I would like to stress, cannot be done in a night or a year. This is a process. And it is important to start the process, and I really believe that when you start, you will also achieve the goal. The goal. I had only 10-15 minutes. I also delivered the written document, and in the written document there are much more information on all these topics I was talking about. So thank you for your attention, and I'm looking forward to answer your questions.
Thank you very much, Mr. Brezovar. I believe that despite the differences in the scale and experience, the Slovenian experience is still very illustrative and relevant to Kazakhstan and to all other country participants that are taking part in this event, and there are over 100 of them, with many participating online. And thank you for sharing the experience with the IQ Justice program. And indeed stressing the importance of the change in culture and methods, that CEPESH is not just about collecting statistics, it's about actually changing the working methods. With this, thank you very much. With this, I would like to move to your colleague, Mr. Bojan Muršec, the director of the Center of Information Technology of the Supreme Court of the Republic of Slovenia, who will tell us about the strategic approach and the strategic view on introduction of IT in judicial systems. Mr. Muršec, please, the floor is yours.
Thank you very much. I hope you see my presentation. I was a little bit afraid because my colleague had problems. Again, I'm also sorry to not be able to participate in person. As the president of CEPESH said, we have to work what's here with what we have at hand. And I would like to make an introduction about the strategic views when implementing IT. This being a high-level conference, it's actually not so much about what we implemented and how we implemented, but more about concepts. And also, I learned from the evaluation of CEPESH, which I studied from Kazakhstan, that Kazakhstan has a very advanced IT system. I was really impressed with the e-cabinet, Torelik, and other solutions. But I also learned that Kazakhstan's Supreme Court is preparing the strategy for the IT until 2022, and maybe this presentation will be of a little bit help. And of course, I will try to show how CEPESH fits into this endeavor of writing an IT strategy, because as the president of CEPESH, Judge Garagurbanli already mentioned, there are many documents and guidelines which can be successfully used in this. Okay. I will talk a little bit about the strategic role of IT in the Slovene court system. As my predecessor said, IT is regarded as one of the 5 pillars of independence, of judicial independence in Slovenia. We have 4 pillars covered. The 5th, this is education, is currently not covered by it's covered by the ministry. But this gives us quite a responsibility to actually be such a strategic operation. So we have to be responsible to our users, because we come from the Supreme Court, from the court system, and our work is to support primarily the users of court system, internally and both externally. The second thing which comes from Center for Informatics being a part of the Supreme Court, it gives us a certain level of stability. It was already mentioned that the president of the Supreme Court has a 6-year mandate, and which enables us also the long-term strategic planning. Also, we are responsible for other court operations regarding the IT, and this is specifically regulated in the Courts Act. And such, we are, as Center of Informatics, is provider of IT systems and services. This is to support the court operations, of course, and also to support the external users of the court system, of the judicial IT. And we, actually me personally, we are responsible for drafting the IT strategy and give it into the procedure of recognizing the strategy, and it is then actually put in place by the Beneficiaries Council, which is actually a body driving all the IT in the Slovenian court system. And we also provide court performance measurement, which was presented before, but we provide the technical part of this project, not the substantial part, which is left to the substantial judges and other personnel. We are also promoter of innovation and optimization of business processes, and what is also a big, I think, a very important thing is that we are also promoter of good practices. We not only promote good practices, but we also bring good practices from others to our country. As said, the IT has a strategic role in the judiciary. It supports and enables many strategic goals and the functions. It has a strategic position also because it collects a lot of information. It safeguards the information, and it also supports all kinds of the procedures in the judiciary. There are also always common expectations regarding IT from the users and from the people in charge, that IT will provide out-of-the-box solutions. Just to implement it actually is not a solution. Usually IT, when not implemented properly, can be a hindrance, not something that we want to see. And it never should be technology driven, which means early adopting of technology just because of the technology, but there have to be real needs and goals underlining this IT endeavor. During my work in the IT, during our work in the IT, since the center was established in 1996, we've come to a conclusion that every project, initiative, or entire court IT can be regarded through 4 components, which we call key components of IT projects. The first one is, of course, legislative component. Our IT systems should, of course, work and uphold the law. And this is not just the law which is base of the current procedure, but also human rights, right to fair trial, actually ethical principles and others. But on the other side, we also learned that we not just have to uphold the law or follow the law by the letter. Sometimes during the implementation of IT, we've come to a situation where we could propose some changes to the law that the procedure can be more optimal, more transparent, or actually more user-friendly. The second one is, of course, technology, the technical component, which Center for Informatics is responsible for. So it has to deal with architecture, with appropriate technology, and also development and maintenance of IT solutions. The third component is the organizational component. We have learned that without changes to organization, that every IT system brings change to organization, and every change in organization brings change to IT. So we have to cover this component very, very adequately, and we have to monitor this component very closely. That means that we have actually to plan in advance all the organizational changes which will be brought upon the court when we introduce a new IT. And so the IT system can adapt to maybe organizational changes which are brought upon the courts by the law or some other document. And the last one, which is many times, I have seen many times that this last fourth component has been neglected. This is a business component. We are not talking about making money or making revenue out of the system, but we are talking about value that we generate with our system. That means that we have to, when we plan IT, actually calculate the benefits and the costs which will be brought to our organization because of this project. Also, we have to understand that we have some previous investments which has to be secured, and we have maybe the obligation to calculate the sustainability of the system. It is not just the costs of implementing a system, but it has also the cost of operating this system over a long period of time. So there is an answer that a document which can actually list all these components and many more things. And this is an IT strategy. Strategy is regarded by CEPEJ, by the guidelines of CEPEJ, and also mentioned in the toolkit, as essential framework which enables efficient use of IT and unleash its full potential. That said, the key elements of strategy, of IT strategy, should at least have the following sections. There should be a declaration what we as providers, as an organization, value the most or value more, and it has to establish kind of a priority system, because with all these new demands for the IT systems and initiatives, it's very important to have a kind of a system with which you can prioritize these initiatives. Of course, there should be a clear definition or declaration of the goals, vision, and the actions that will follow. And of course, that also a kind of a promise or a pledge what will be done during this, the value or the validity of the strategy. And of course, it should have some parts where governance, organizational culture should be defined, how the things will be done, then what is deemed as important. Of course, here we can also talk about, for instance, artificial intelligence and the ethical charter, which tries to regulate this ethical things. And of course, it should define the scope of the IT system. That means the boundaries to which the IT system can actually help and will help. The adoption of the strategy actually provides a stable environment for the period of the validity of the strategy. The strategy is, of course, long-term in nature. It is typically 5 years or more. And of course, it provides the common understanding among all the stakeholders which are in the IT of judiciary. And it can sometimes also act as a in dispute resolution between stakeholders where there is a quarrel or a dispute about the priority of some or other IT system. The governance principles which should be included also have to be covered by the provisions of governance in the strategy. As I said, there should be a clear definition of the procedure for proposal, evaluation, approval, and discontinuation of IT initiatives. There should be visibility planned all along the IT initiatives. That means visibility means also publicity. It means informing the users, informing the stakeholders. Of course, the stakeholders should be included as soon as possible from the beginning of the project. And they should be included formally, not informally, and be a part of the development of the system. Of course, they should have the opportunity to be heard, and their views should be taken into consideration. The strategy should also define the ownership and responsibility of every IT initiative. And of course, I have come to a conclusion that project management is also a good thing to be in the strategy. I mean by project management also the composition of project groups. In Slovenia, we have a very good experience with a dual system of project management, where one of the project manager is from the technical side and the other is from the currently normally a judge who brings the knowledge and expertise of the procedure to the table, to the project. So the project ends up being relevant and ends up being also usable to the users. The next thing is about more technical, but it helps you when you build the system. When you build many systems, it provides also that the systems are built in uniform architecture. So you don't have many different silo systems which are actually hard to be sustained. Also, there is an idea of common building blocks. I have attached a list of these building blocks as an appendix to my written submission, which also is much more informative than I have time to express in these 10 minutes. And good practice is also reusability. That means everything what we develop should be developed with reusability in mind, so it can be used by other systems. And a big part of this is interoperability. No system should be designed as an island, as a silo. It should be designed with communication in mind, with connectivity to other systems, to users, to other countries. And we have many EU initiatives which are aimed exactly to do this. We have ULIS, we have ECRI, we have ECODEX projects, which are essentially cross-border initiatives to provide the systems to be able to communicate with each other and to exchange data in documents. And of course, use of standards. We are actually really much relying on standards. When there is an open standard accessible to all, then we try to use it. Where there is no standard, we try to establish one. But we try to standardize things before we embark on the IT implementation. And of course, we cannot forget the users and the support of the IT initiatives. We have to, as said before in the business component, think about sustainability of the system, from cost recovery to long-term maintenance. And we have to plan for this. And of course, the crucial part of the system is training. If you don't train your users, they will be resistant to change, and they will use the system in ways which are not meant to be. Of course, we try to have to enforce the uniform use of information solutions, because uniform use of IT tools also leads to uniformity of business practices across the judiciary, across the country, across the courts. We should raise confidence through the strategy, and we should include people who are on the other side of digital divide. So we should promote digital inclusiveness. And we should assure all the users that nobody will be left behind. Of course, we have to think, and it is very good to write it in the strategy about what the IT system will not do. They will not discriminate, and they will bring no harm to the users. And of course, they will not breach any personal data directives. And the last things, which is a wish, actually, because it cannot be mandated. It's a community building. If you have an IT initiative, it's very good sense, common sense to build a community around it. With not only users, but also the people who are in charge of developing, maintenance, and also the use of the system. So, having said that, there's a little mentioning of where CPES documents come into play with drafting a strategy. Although CPES is aimed on improvement of the efficiency and functioning of justice, in the last years, it's more and more concerned with the judicial IT, because judicial IT can be directly linked to the efficiency and functioning of justice. And we have seen this intent also in forming a new working group, the CyberJust working group within CPES, where I'm proud to be an expert on this working group. And also I should mention the publications which we use in drafting the strategic documents. The guidelines on how to drive change towards cyber justice. It's not a very new document, but it still stands with its guidelines. And the toolkit for the implementation of the guidelines to cyber justice is a hands-on document which has an entire section with hints and guidelines on how to write the IT strategy. And with the advent of artificial intelligence and new technologies, CPES is closely monitoring the effects this new system can have, both positive and negative, to the judicial system. And I should mention the European Ethical Charter and the endeavors of feasibility study on establishing a certification mechanism for AI, which will be enabling us to actually check if our system has a green light regarding the AI. And of course, I mentioned the new GT Cyber Justice Group, which will produce quite a few guidelines linked to cyber justice. The first one, the guideline on video conferencing, is already published. It was published very recently. Now we are working on guidelines on electronic court filing, e-filing. Of course, you can see 2 more documents are in the pipeline to be actually published. And there will be many more, I think. And so you can see that CPES and the Council of Europe actually are more and more involved with the IT in the judiciary. So what can I say for the And the lessons learned from the IT in the judiciary over the past 15 years, which I have come to, is that, which was already mentioned, the IT is not a solution by itself. It's just one of the key components, one of the 4 components. Stable and well-defined IT strategy is a path to success. And if you have the strategy, then stick to it. Don't change it daily or monthly or based on the public opinion, but it gives you the long-term stability to actually be able to do things. You use the IT wisely. That means there should be no technology-driven use of IT. There should be needs-based, business needs-based IT use. And use the experience of others. This is exactly what I'm doing right now. I'm sharing my experience with you, and I hope that you will also be able to share your experience with us. That means promotion and exchange of good practices, also bad practices. You have not to be shy over some bad experience you had. It's also good to share that someone doesn't step in the same problem. You should promote interoperability and linking of the system. It means at the service and data level, and of course the reuse of what has already been developed, modules, services, and data is paramount if you want to sustainably drive the IT support for years. Thank you very much.
Thank you very much, Mr. Murshets. Спасибо огромное.
Thank you very much. I think that a presentation of Mr. Murshets clearly showed importance of strategizing of IT application and use, and also showed both definitions of efficiency and performance. When Mr. Papashvili at the beginning mentioned that it is very difficult to translate, efficiency is very difficult term to be translated, because as Mr. Gurbanli said, it's not only about efficiency but effectiveness of justice. It's not only about using resources, optimal use of resources, both human and material resources, but also in terms of the effectiveness of the justice. And from this regard, presentation which we just heard perfectly illustrates importance of that when you implement IT technology, you should both take into account efficiency and effectiveness, both in its both senses. In Russian, it is still one word. Mr. Murshets also mentioned Kazakh experience in the beginning of his presentation, and I think that more details about Kazakhstani experience will be shared by our Kazakhstani colleagues. And I am glad to pass the floor to Mr. Nursultan Talenovich Baytilesov, Deputy Head of the Judicial Administration of the Supreme Court of the Republic of Kazakhstan, and he will tell us about digitalization of courts and application of IT technology in the process of justice. Thank you very much, Mr. Karapetyan. Good evening, dear participants of the roundtable. Previous colleagues shared strategic, efficient approaches in implementing IT in judicial systems. I will try to do my best and not to let Mr. Murshets down, who actually complemented IT and digital achievements of Kazakhstan. I will try to briefly share our experience. Greetings, dear participants. As you probably know, today global community, including Kazakhstan, is oriented towards implementation and the development of IT. Digitalization of a judicial system is not the goal on its own. It's just as a compound of the today's justice, mobile, transparent, and accessible to everybody. What is being done by the Supreme Court, what has been achieved, what kind of trends and perspectives of further developments are prevailing, what are we doing for the convenience of our population. We opened a one-stop shop for access through the judicial cabinet. Clients can go to e-format, and this service, as we know, last year from the pandemic lockdowns in many developed countries, some activity was suspended in terms of the courts, and some courts were closed down, and all the trials were suspended. This was a breach to communicate with populations. That's how they sent their claims, motions, and so on. And we were able to be in touch through this tool. We have more than 600,000 users. Before we had only 5% of the claims coming online, and now this indicator is more than 92%. Also, for the convenience of users, we have different services available. E-dispute resolution, online settlement, online constructor for claims, and the bank of the court deeds. And based on the feedback from the users, we can automatically build claims. And in the bank, we can add any judicial resolution, a court resolution in line with a specific parameter set. On a daily basis, we have more than 1,000 searches like that. Starting from 2016, in the courts, we have Torelek system launched. This is centralized information analytical system providing operational access to data exchange. Thanks to this system, we moved to e-format of judicial system. We have intellectual assistance to judges. For example, during the resolution preparation, we can have tips on the possibilities of punishments and other measures. Starting from 2019, we have implemented successfully e-criminal case, starting from the claim made after the criminal case was opened and up to the resolution by the court. All the procedural steps are implemented online. If in 2020, out of all the cases, the share of e-format was about 32%, today, in 9 months of 2021, we have more than 46%. And also it's audio and video recording of the trials, and for objective observation of the whole procedure. It is a discipline for all the participants, also for the chairing judge. This system simplified significantly the work of the secretary of the court. If before secretaries had to make the protocols manually with audio and video recording, there is no need anymore. We have IT services, and they changed in system of interaction with courts and ensured next steps. Today we are at the start of launching 2 projects. This is digital judicial analytics and robotics. We've developed this system of digital judicial analytics. This is a similar cases, analytics of abnormal resolutions, and follow up life cycle by instances, and also forecast of the outcome of the case in court. just with one click, it will be data provided about the relevant cases. To external users, it will be also to objectively assess their chances before going to the court. We believe that it should become a real assistant in implementation and developing of unified judicial practices. Throughout the year, we tested this module. We piloted it, have had test runs, and we are still collecting feedback from our users, what will allow us to improve this tool and also to launch later. As a next important development is about robotics in the judicial system. Using specific algorithm, the decision-making the robot will help to prepare to draft resolutions where we are limited by the legislation. For example, sanctions on for example, prohibition to leave the country for people with debt, or allotments. This robot prepares the acts and then judges will sign it. It will decrease routine workload, will exclude human factor, and will decrease the procedural time frame. Coverage will be more than 100,000 legal acts, 1/4 of the previous year workload. And approval signing decision will be up to the judge. Constitutional rights are not violated. If there are technical errors, they can be fixed by the judge himself or herself. Today we have the technical implementation stage. We understand that with advantages using this artificial intelligence and robotics, there are also risks associated with that. With the development of technology, we have in mind all the requirements to align our procedures with the European party. Technology will never replace judges. It should be experienced background, judicial practice, legal knowledge, psychological knowledge, and artificial intelligence will not be the same as the human brain. And we will be implementing the best international standards of informatization. That's all I had. Thank you very much for your attention. Thank you very much, Mr. Batilesov. We think that your experience might be interesting not only to Central Asian colleagues, but also to member countries of the Council of Europe. Problems you are tackling are being addressed currently by many countries, particularly with artificial intelligence, and the Council of Europe in their internal systems is also working on some of the elements you mentioned. And I think your experience might be very interesting to many parties. Next speaker, Mr. Ildom Shaganovich Zhumaksanov, judge, deputy head of the judicial administration of the Supreme Court. He will tell us about communication with public as one of the efficient elements of the judicial system. Mr. Zhumaksanov, please. Good evening, dear colleagues. Thank you for this opportunity. We were really interested to hear presentations by our colleagues. It was really great to exchange experience. The key goal of the judicial system is to streamline judicial procedures, but it will be efficient not only if we draw on our own experience. But also, in my understanding, in our understanding of the Supreme Court, we should also bring to the knowledge of the population what we do, what kind of efforts are being done, what kind of steps are undertaken to improve this work for the judicial system to be efficient and effective. And our task is to communicate, educate, and to get feedback from public, to use in our work previous mistakes and lessons learned, to agree or disagree, but at least to improve communication and interaction with public, to have a constructive dialogue. What we do for this purpose. Last year we had the year of the quality of communication improvement. Before, we used to have communications all the time. The question was about the level of communications, more in a on a more higher level or on a less higher level, to see some nuances we are missing. Probably we have them or we might not have them. We have such a communication center established which would analyze all the work and will educate and communicate with the public on how it is being implemented. Communication center was established under the Supreme Court, and often very commonly we never argued against the factor that traditional outreach should also exist. It was tested with time, and today in a systematic manner we have briefings. That is Mr. Aslan Sultanovich here. Unfortunately, he left the room now, and we have this communication service on a central level where all the mass media is invited. We provide information on our work, and this is a systematic event. Next, in addition to that, we have a central TV channel Khabar, and for the second year already we have a TV project, a case of particular importance. The particularity of this project is that after the verdicts are made effective, the judges of the Supreme Court tell about these cases with examples. Not only judges, but this program also involves and engages explanations and information on every second case. It is by attorney, plaintiff, defendant, prosecutor, judge. The coverage is universal for all the stakeholders and parties. I'm sorry, it's not for 2 years, it's already for 4 years. On this basis, all of that is a standard, traditional method of communication, but with the progressive development of social networks, taking into account the pandemic lockdown, that people are working online and everything is done distantly, we also changed our format of communication. Traditional mass media, when they publish information, it is actually being further widened by social media, or sometimes from social media it goes to mass media. There are some very widely observed cases. It's not only criminal offenses, both civil and criminal cases. Why people do not understand that? Because they can't get why this verdict was made. To make it understandable, on the basis of the verdict made on the case, there is a briefing with and in simple words it is explained why this verdict was made. This video is being then saved and uploaded. Every district court Court and regional courts, they have accounts in social media. I will tell about that a little bit later. On the official Facebook pages, we publish work about this court activities, not only about a meeting, a roundtable, or a seminar. Approaches change, and now we publish information about cases, not about every case, but about particularly interesting case, which might be of a particular interest to the public. And that is about a little bit explanatory and educational activities. For such particular cases, we have broadcast on the social media pages. And also with our regional courts, we have mandates for the judges responsible on interaction with mass media. And in Supreme Court, we have 3 coordinating judges on the same specialization. On the left, Ms. Nurgul, Yelena, and Galima, who are specializing and are coordinators for the social media accounts. And Marina, Galina, Gulzia, those are the judges from regional courts. At least once a week, they publish some posts, for example, about the administrative procedural code or the practice of case consideration. And this is explanation and education. And today, these pages for some legal community are of interest. If they even use it in their work, and there are comments, there are questions to follow, and judges respond and provide their answers. If before we had 7 pages on Facebook, every page and every group was dedicated to specific topics: courts and media, criminal justice, civil and administrative procedures, and so on and so forth, conciliation procedures. From last year, we optimized all of that. We have now one group. It's called Smart Thought IT Justice, IT Pravosudие KZ. Today, if there are any questions or suggestions, ideas, misunderstandings, we work only in this group and not on any pages. We want to try to be very quick and very detailed. We've created a platform. It is called Communication Center on .kz. On this platform, we have accounts and contact information for courts, also the guidelines with the statistical data. In the media project, it has Khabar, YouTube channel, and other programs. Explanations on the judicial practices. We have information from the Supreme Court judges and also information from the website of the Supreme Court and of the Supreme Council. And I would like to bring your attention to accounts and contacts of the courts. After analyzing Smart IT Pravosudие portal and group on Facebook, mostly it is about we cannot get hold of the secretary because he is attending some proceedings, or we cannot get our calls answered, and so on. We have such an interactive map of courts. If there is a question about the Nur Sultan city courts, they can press the button of the city and they go to the district courts in the city of Nur Sultan. And if there are questions to the particular court, for example, if it is Almaty district court, it also has mobile phone number. And if there might be some charged calls and so on. Sometimes it is busy. You can call, you can press this number and you go to WhatsApp Messenger. And if you have questions, you can ask all your questions. You can ask the status of your complaint, the verdict, and so on. And the secretary is a particular focal point in the court, responsible for liaison with public, provide detailed information. Those from social media, we brought these people into the internal channels of communication. Next slide. Today we have courts of Kazakhstan are present on Facebook, Instagram, YouTube, Telegram, and we also, after having the administrative justice, we have a page on LinkedIn. And Yerlan, next, we have Instagram accounts for Supreme Court and the judges, and Mr. Jacob already mentioned, with new administrative justice starting from June 1st, we have a separate Instagram account, administrative justice, where all audio, video, all posts, all publications of the cases considered on practice, on all the videos are being published on our Instagram account. Therefore, today we believe that the efficiency of justice is not only about quality work of the judicial system itself, of our judge colleagues, but also outreach and explanation of our work to public, explanation of the legal norms, and that will improve trust into the judicial system. That's what we hope for, and we think that this fact that we are open to work with public provides its positive effect. And while we are working here today on the four portals, there is information about the reform. In parallel, there is a broadcasting on YouTube and Facebook. Public can follow our news. We have press secretary of the Supreme Court, Mr. Sadvakasov. He is also active on social media, about 8 to 9 posts for each speaker. And I am sure that based on the results of our roundtable today and tomorrow, we will have more requests to come, because the legal community is following up all our news in a good sense and always asks to share information we are discussing here. Not all the people can be connected, can ask their questions today, and if speakers don't mind, we will be using this material shared today for further future publications. Thank you very much, Mr. Ildos. Very interesting presentation, very detailed work and effort to communicate with the public in every possible channels. Even social media is covered. I think it is a very interesting experience, and we discussed CEPESH. Now Ms. Adiya Nurlanovna Ramazanova, national correspondent for CEPESH in the Republic of Kazakhstan, and also leading consultant of the project office of the Judicial Administration of the Republic of Kazakhstan, will tell how Kazakhstan is represented in the periodic report of Commission of Europe on efficiency of justice. Adiya, please. Good evening, dear participants of the roundtable. Thank you for this opportunity. As I will be the last to speak today, we had a very productive day, and I will be elaborating more on some key aspects. Being national correspondent of CEPESH, I would like to show, as it was mentioned earlier by the speakers, Kazakhstan from 2018 has an observer status in CEPESH, and the first report we participated in was for 2018-2020. And you know that this report is published once in 2 years. Based on the country statistics, it covers separate aspects of the court's activities, prosecutors' offices, justice bodies, mediators, and so on. report, as it was mentioned earlier by Mr. Garagurbanli in his speech. This report is quite high authority international resource of official information used by different organizations globally for comparative analysis. What is an advantage of participation in this report for Kazakhstan? What are the benefits? First of all, it allows us to become part of the methodology of the performance assessment used in European countries. Number two, it gives us a possibility to compare our indicators with other governments, to observe common trends or differences. It allows us to study data on a group of countries in line with some analyzed parameter or indicator of the judicial system. And number three, through this report, we can inform international community an objective picture of our current status in Kazakhstan. And also, inclusion of Kazakhstan into the map ensures our policy of transparency, implementation of best international practices in the judicial sphere. Throughout the whole period, collection of information and up to the publication of the report in October 2020, CPESH Secretariat provided significant support and assistance 24/7, and we appreciate their help and assistance. Together with Secretariat, we organized introductory seminars in 2019. It was a very interesting and informative experience. A publication of the report allowed Kazakhstan to pronounce itself in the European system of judicial coordinates, showing what we can be proud of and where we should be focusing more. On several positions, Kazakhstan showed quite good results, even better than average European indicators. For example, on use of IT technology in courts, we've got 9.23. It's number 4 after Lithuania, Portugal, and Estonia. Another good indicator, the average period of the consideration of civil and economic disputes. We have 32 days duration, and if to look in Russia, 50 days, in Ukraine, 128. Average European is 201 days. Also, it should be noted that there are no cases in execution for more than 1 year. It means we don't have too much of a red tape. In terms of the level of communication in the civil cases, we had 10.4, and that is more than an average European grade. Pandemic lockdown and our online work was a proof that in CPESH we have all this procedures streamlined. Secretariat of the Council of Europe assessed positively activity of Kazakhstan within CPESH procedures and provision of all the documents despite the COVID-19 crisis. We used data as of 2018, but since then our judicial system went through significant changes, and part of them were discussed during our round table, and we hope that the results of these reforms will be reflected in the current cycle of the CPESH report. It is real pleasure to see that the government authorities of Kazakhstan are more and more often to use statistics of CPESH data, and they are using this in their work. And the last slide, last but not least, CPESH is a big team of highly qualified professionals, and it's a big pleasure to be part of it. Thank you very much for your attention. Thank you very much for your presentation, Ms. Adia. Even though your presentation was the last in terms of the sequence, but it's not least in terms of its relevance, because it shows applicability of European standards in the countries which are not members of the Council of Europe. And the examples you showed how we can measure our progress of reforms of judicial system in Kazakhstan by so-called by European system. It can show us on a more global indicator, and also show what kind of experience is more interesting and relevant for you. CEPESH is a big friendly team where we share information, because this information sharing is very important component. We are almost on time following our agenda. We still have discussion, and I think we should provide a possibility to answer questions both to speakers, and if anybody has anything to add, please go ahead. I think that it's already late and time is not in our is not pro us now, because it's lunchtime in Europe. It's 6:30 in Kazakhstan. I think that we had very profound and detailed presentations. I would like to thank all the participants, all the speakers for your contribution, and to previous speakers. I would probably provide the floor to Mr. Kuznetsov. Back to you for the closing remarks. Or thank you very much, Tigran. I think that overall conclusions will be drawn tomorrow. Today, I think we had a very positive outcome. Just one disadvantage: we would actually enjoy more time for such important and relevant topics. But I think it's not our last event. It will give us the beginning of the follow-up activities, which will be dedicated to the specific topics where we want to cooperate and to work together. I appreciate this very productive and important day. Thank you all, and I hope we will continue the same constructive dialogue tomorrow. Thank you very much, and see you tomorrow.